No, clearness of conviction, my lord, already quoted 11 years, my lord.
My pardon, your lordship. My lordship, CRLA 151/18. The accused person is an old man, having 72 years old, and has been languishing in the custody in Nalsal Road.
This is a place admission where petitioner is not allowed to participate in the interview going to be held on 8th. Kindly be taken up tomorrow, my lord.
Which interview?
My lord, conducted by the UPSC. And I am challenging the order of this honorable cat.
You have not been called for interview.
No, my lord.
What do you want?
To participate in the interview because honorable tribunal has passed order subject to result of the original application.
Yes.
The similar matter, the cat is subject to result and allowed to participate in the interview.
Yes.
But in this case,
In your case, that has not been done.
not been done.
Then, is there any order of the Central Administrative Tribunal
Sir.
in your case?
Sir,
So file a contempt petition. We are not here
no.
to.
Central Administrative Tribunal director only subject to result, not allowed to
Yes.
participate. And that order I am.
Yes. What can be done? Tomorrow is the interview. We can.
My lord, the eligibility criteria, my lord, kindly be taken up the order is.
Yes.
My lord, an application.
May I be pardoned, my lord?
My learned singer.
I am on virtual mode.
Yes.
Denotification matter relating to the coalfield we have filed, it is very urgent. May I pray day after tomorrow on 7th, can it be listed, my lords? My associate is there, he will give the memo, my lord.
Yes.
I'm not well today.
Okay.
Sir, otherwise me allowed to participate, but I am not discriminated.
No, cannot.
I am discriminated, my lord, sir.
Yes, call me.
Pardon to mention, my lord. Item 20 or 21?
Let the matter issues will go seriously.
Okay.
Pardon me, Lord, item number 69, pre-withdrawal.
Yeah.
Is
69.
my lord,
There is no 69. 16.
my lord.
WPC number 6072 of 25. Is there any interim order?
No, my lord.
You have to. What's your doing?
Interview two years. Let it come after vacation because I have not completed instruction. I told you.
The Learning Council for the petitioner files a memo to withdraw the writ petition. Memo is taken on record. Petition is disposed. Yes, next.
Item 11, I'm taken 11.
Withdraw.
So,
11 withdraw.
Next week.
Why are you making mention? Yes.
Weekly list, item number 1.
Yeah, dude. You must see. The land is recorded by the railway department. The land is recorded jointly with the father of the prisoner along with the other. Plus, will be directed the commissioner to disburse the compensation amount. It is actually annex of 5 lakhs running by 70. Annex 70.
What is your prayer?
Prayer also disburse the compensation amount acquired by the railway department.
No, the land belongs to the deity.
Let's see.
Too high compensation will be paid to you.
Here, let's see this annex of 4 also. And gas annex of 4 running by 16. Pursuant to the representation filed by the petitioner, the authority has communicated that the money has been kept with the underwent commissioner. Here,
Who are you?
I allow the record. I filed the RO that the annex 1 running page 8. The land is jointly
Land
recorded.
recorded in the name of the deity.
That's it. Sri Radhakanta Dev, Sri Radha Mohan Dev, Sri Gaurang Dev, Vijay Nija Marfot, Mas Kushtananda Das, Guru Nityananda Das, Jati Vaishnav Das Nija.
These are disputed facts to be looked into by some authority.
He is the only Marfot of Kushtananda Das, and the petitioner is the son of the Kushtananda Das.
Adjudication is necessary, evidence may be required.
So already I filed the, lordship, the voter I card and the PAN
No,
card.
it cannot be
The
adjudicated.
public duty, then you cannot.
Public duty
So
is-
something that endowment moved. it to
File the
endowment
appropriate
commissioner.
application before the endowment commissioner.
Commissioner. You can examine and discuss.
Study liberty, I approach the.
Yes, petition has been filed by the, it has been pointed out by the stamp reporter that all the defects has been removed by the petitioner. Stop. This writ petition has been filed by the petitioner Devananda Das. Prayer for a direction to the endowment commissioner for payment of land acquisition compensation amount in favor of the petitioner within a stipulated time. The land counsel for the petitioner referred to the land acquired under the ROR, the compensation in respect of the land acquired under the said RR should have been paid to the petitioner. However, after arguing for some time, the land counsel for the petitioner seeks permission to withdraw the writ petition, to seek for appropriate remedy in accordance with law. According to the writ petition, it was disposed of, giving liberty to the petitioner. Yes.
Public.
Item 2.
The settlement the appellants are challenging the judgment passed on an additional district of Sundawar dated 25/4/2025 and offense under section 302
Right.
like.
First up, there is no criminal matters that I counsel. It is the second up. Now, Mr. S.K.Sahoo is not there. So I pass over.
Item 3.
May I please? The last order, the lordship called for the report from the honest presiding officer of the,
Which order?
by order dated 9/4/2025.
Camp manager on the protocol for the matter. The report of long disclosure on the
Here the sole question is whether the reference to the tribunal, a reference is necessary or the petitioner whose land has been acquired, he can directly apply. In fact, under section 14(2), if the reference will not be made by the MCL authority, then the petitions can file the, approach the tribunal. That is the language of section 14(4). To clarify that, you will.
Just a minute, yes, from the state court counsel. The learned additional session judge has answered to our query. So, and he has also sent the relevant act that is the Coal Bearing Areas Acquisition and Development Act 1957. And he has mentioned so why don't you go through it? The and query made will just Xerox copy to you and just examine, and both of you also go through it so that you annex your one doesn't देखो you चिट्ठी रे आसीची
So I only find one judgment in this line.
just a minute you go through it
Madam.
it annex your one तादरे additional session judge को जो येटा अच्छी এবং जो letter টা আছে সেটাও কাটি ইয়ে করে দিন but বাকি তক तुमको ইয়ে করে print out করুন
CP Act and the rules are available with me.
No, we are not giving you the. He has analyzed himself that what is practice is no.
See if maybe
It would be relevant. কেবল সেতিকি সেই 3 পেজ বুঝি পারছো তো एक रु 102 नुहे mentioned. So that's
so कौन दूसरा देखिए आप कौन थे देखो मैं कोड़ा दूसरा देखिए कौन पढ़ चुके आप कौन वहाँ पे ठीक है
next one. Is your signature तक ये कर लो है ना original data copy दे दो ये annexure one भी करना है ना the land council for the
6, 7, 8 3 दिन में इलेक्शन केस टिके अच्छी.
acha next week as you
Next week,
the land council for the
But-
petitioner so also the land council for the state 6 adjournment till of this matter next week कर दियो तो है ना ଗୋଟେ matter लिखी देवे order टा and that is to come along with WPC number 3224020 है ना just receive it
Madam.
Mr. Mahanti you also take it huh
Item 4,
I recommended application incorporating the legal heirs of the recorded tenants as per annexure 2. Most of the recorded tenants.
just a minute it appears that in the prayer portion it is mentioned to allow the amendments shortfall as specified in the schedule, but there is no schedule to the property. Land council does seek permission to withdraw the interim. अच्छा file को ले आओ गुड नुआ
Yes, ma'am.
7379
Yes, yes.
schedule देइछन्ती
Yes, ma'am. I have
चलो फामन कॉपी देले
there.
other side का की छन्ती
Yes, some article. MCL has not yet appeared.
स्टेट नहीं नहीं MCL छाड़ो हम स्टेट को दे देले
Wait
तो
a minute.
देखि देइछन किछ ऑब्जेक्शन नहीं ना कौन कहिबे कौन नेचर ऑफ अमेंडमेंट
Mr. Amendment ballot.
जीनियोलॉजी तो अच्छी आ गोटे कोन खाली तो सेति आउ तो किछ नहीं
ନାଇଁ ଆଉ କିଛି
এটা পারা 3 রে আড হবো না কোটি
Para 3 টা ফের আড হবো thereafter para 4 আসলে there is no renumber.
ওকে ওকে প্যারাগ্রাফ 3 The following paragraph may be added as fee and subsequent paragraphs may be permitted to renumber accordingly.
Hmm.
4 to 19 ହେଇଯିବ ତାମାନେ ଆପଣଙ୍କର ରିପିଟିସନ ଟୋଟାଲ ପାରାଗ୍ରାଫ ଅଛି
Hmm.
18 ବର୍ତ୍ତମାନ ଏଇଟା ଇନସର୍ଟ ହେଇଯିବ ଆଉ ବାକି ସେଗୁଡାକ ସବୁ ତଳକୁ ଚାଲି ଆସିବ ଏଇଆ ତ?
Sir.
Yes, Mr. Mahanti, what do you say? All right.
It will allow consolidated.
IN number 7379 of 2025 is an application for amendment. After going through the above taken in the interim application and hearing the land council for the state, the proposed amendment as mentioned and the schedule of amendment is allowed. I is disposed of the land council for the petitioner 1 week time to file the consolidated petition. We are giving you 1 week time, you file the meantime.
Yes.
And serving a copy on the land council for the state. All right. Good. It's all right. Same order to be passed in all these individually for you. And put the last two like this petition is to be listed along with WPC numbers 1. In the IE order to individually dispose it. ସବୁଥିରେ ସେଇ paragraph 3 ଟା ଆଡ ହବ ନା ଅନ୍ୟାନ୍ୟ କିଛି ଅଛି?
Item 5.
Item 5, my lord, order letter 15/4/25. The lordship directly state to take the instruction about the status of the resolution case number D of 9596.
We'll pray for some time because we have contracted the record is.
You have already sought for instruction.
Yes. Store service.
Okay, and the land council for the state submits that as per the order dated 4/2025, he has sought for instruction regarding status of resumption case number 3/1995-1996, which is stated to be pending before the opposite party number 1, collector, district magistrate Khurda, and some more time be granted in that respect. To differ of the put up this matter after answering some of the question. Yes.
Item 6.
Yes, Mr. Panda.
Matter used to Withdrawal lease, which is covered under Northern case that has been remanded by the Honorable Appellate Court.
One list has their cover up.
Set alga type. Let's say private land where ASO has refused to correct the same, those cases were challenged and direct order was passed that in case they produce any document, ASU is bound to make necessary correction and issue ROR. So that was challenged before the state, before the Supreme Court. Honorable Supreme Court has made the order that it is to be first seen in individual cases as to whether he has exhausted the alternative remedies or not. So that is the order passed by the Honorable Supreme Court. So all those matters have come here. And we have, wherever we found that alternative remedy have not been exhausted, we are asking the petitioner counsel giving liberty to exhaust those remedies and if necessary, then come to the High Court. So in your case,
So for mine one is concerned, that is Withdrawal.
so what has happened in this case?
Well, actually, when you come to Annexure 1, page 12.
Before the submission, the lordship may have a glance to list of dates. Let it be detailed. The list of dates are being given so that it can be clear clarity. Date which is.
He's right.
Yes, see, document relate with date na.
She's not
With
dated.
synopsis ଗୋଟେ ଦେଲେ ବା
ଡେଟ୍ ଟା ପ୍ରଥମେ ରହିବ ଡେଟ୍ ଚାର୍ଟ ମାନେ ଡେଟ୍ ରେ ପ୍ରଥମେ ରହିବ ଇଭେଣ୍ଟସ୍ କଣ ହେଲା ବା ଇଏ ତାକୁ ପରେ ଦେବେ ଆଉ ରିଲେଭେଣ୍ଟ ପେଜ ଅଫ ଜମାବନ୍ଦୀ ରେଜିଷ୍ଟର ଆନେକ୍ସଚର 1 ଏଗୁଡା କଣ ଏମିତି ସବୁ ଦିଆଯାଏ ଡେଟ୍ ଚାର୍ଟ furnish a correct date chart so that we can know केबे जवान लीज ग्रांट हैला कौन तापरे प्रॉब्लम है कौन है ये सब टाइप रो दियो तो लगो the learning council for the petitioner seeks some time to file a list of dates and events praise list for them put up this matter केबे रखियो कौन after summer vacation.
Item 7.
Same.
Even also same after summer vacation.
Item 8.
It's time to action.
We may allow that. Even for we have issued letter, we have not obtained, we pray some.
Just a minute. Order dated 10/3/25. To assess the compensation in respect of transfer to disburse.
The road construction is there, same issue that
So that the planning question has been reported again. Krishna Chandra Saraf his father. And counsel for the petition of Robert do the attention of the Anashat, which is the order dated so and so. In same which would show that land in question has been used for public road since last 30 years or so. And counsel further do the attention to show that Krishna Chandra the father of the died in the mentioned then the petitioner is now the only legal heir of so and so. So why have you come alone? If you are not the only legal heir, suppose state is of course to take instruction regarding payment of compensation or not, whether your father has received the compensation or not, obviously because that took place in 30 years back, that instruction is to be, but it is your case that you have not received your father has not received any compensation. But if there are other legal heirs, if they are not ready to approach or join you as the petitioner, should have made them as opposite parties. You are not entitled to get the compensation alone. Have you made them parties? Then you will take the entire money or what?
You make them pro forma respondent at least.
So who are how many legal heirs are there? That is annexure number कैसे?
The genealogy pay separate genealogy.
Annexure 4.
Pay separate. So the eligible one, that you type.
No, where is that legal heir certificate? Why have you not furnished the legal heir certificate? Furnish the legal heir certificate and add those persons who are also have a right over that compensation amount if not paid. They are to be added as opposite parties in the writ petition. Look, the learning council for the state seeks some more time to obtain instruction. Stop. Subparagraph. Learning council for the petitioner submits that he will file the legal heir certificate of his deceased father, Krishna Chandra Saraf, and take necessary steps to add the rest of the legal heirs as opposite parties by filing interim application for correction of the post title. Put up this matter after summer vacation.
Annexure 4 genealogy अच्छी.
Genealogy अच्छी तो फिर कौन है तो legal heir का पढ़ा है कौन है ठीक है. One on the back is no money sitting over.
Item 9.
My lord, I am on behalf of Sugatam, take this matter after vacation.
What is your good name, learned counsel?
Santanu Kumar Behra.
Santanu Kumar Behra. You are making a mention on behalf of Mr. Shamir Kumar Mishra. Any interim order has been passed in this case? No. All right, Mr. Santanu Kumar Behra, learned counsel appearing for Mr. Samir Kumar Mishra, learned senior advocate, seeks for an adjournment. Put up this matter after summer vacation.
Item 10.
No, please, your lordship. Lordship, may kindly have a glance over the previous order dated 16/4. The lordship directed the state council to produce the record.
Just one.
You have got the record?
Leave some time.
ये मेन कंटेंशन होची केस पोस्टिंग हला 7/11/2024
तीन
प्रीपोनिंग कर देई किनी नोटिस जदी नथिबो से लिखि देले जे
They have start regards to your lordship's order. Your lordship's diary in Annex 9. That they should hear the question of maintainability as well as limitation cost.
You have seen.
And that they have no, and that was also the direction of the apex court. And ignoring that, he has preponed it.
So we are keeping it next week. Mr. Mahanti, learned an additional standing counsel, 6 for an adjournment till next week to obtain the entire case records of OEA revision case number 6 of 2015 from the opposite party number 3 as per the order dated 16/4/2025. Of this matter will be commencing from 12th of May 2025. And senior advocate is present for the
Item 11.
Mr. Biswal. Pass over column.
Item 12.
Lordship, may kindly take the passover, Lordship. I'm appearing through the PC, Your Lordship.
Which item you are mentioning?
Item 12, Your Lordship.
Item 12, you are for the?
Petitioner, Your Lordship.
What do you want?
Passover, Your Lordship. If may, Lordship may grant a passover.
You are for whom?
Your Lordship, I am appearing for Puri municipality. A petition copy is needed to be served upon Your Lordship.
Puri municipality?
Yes, Your Lordship. We haven't received the copy of the petition yet.
Puri municipality is not a party here?
Your Lordship, Your Lordship, in noting, we have also filed our appearance, Your Lordship.
Why you file the appearance? You are not a party. We have not allowed Puri municipality to be implicated as a party. Neither there is any prayer made by the petitioner to that effect, not to. We have also indicated anywhere that the presence of Puri municipality is necessary. Is there any order?
My lord, I am for the petitioner, my lord.
Yeah.
My lord, in this case, the petitioner number 2 has died. So on the last occasion, we have also filed one interim application for substitution, my fellow. And on the last occasion, my lords had directed us to file the legal certificate along with the death certificate.
Yes.
And we have obtained the death certificate, but the legal certificate we have
No,
applied.
it's all right. That's a different matter. But
Your Lordship,
you are the. Have you added any Puri municipality as a party?
My lord.
Which one? Which order? Where is your prayer to that effect?
My lord, we have amended the application, my lord.
No, amendment means there should be an order of the
My
court
lord, my lord.
to that amendment.
Order dated 24/3/2025, my lord.
Let us see that.
There is an IA.
Hmm. Okay, there was a direction to file the consolidated cost title of the writ petition. Have you filed that?
No, my lord.
Why?
My lord, because the petition number 2 has died.
Okay.
So
Cost of
once the substitution is allowed,
The Land and Counsel for the petitioner submits that while allowing the interim application, IN number 4603 of 2025, which was filed for amendment of the writ petition to include executive officer Puri municipality as opposite party number 4, the petitioner was directed to file the consolidated page of the cost title of the writ petition, but since the opposite party, petitioner number 2 has died in the meantime and is to be she is to be substituted by the legal heirs, and for that the order was passed on 15/4/2025 in IN number 5295 of 2025 to file the death certificate of petitioner number 2, so also the legal heir certificate, he is having only the death certificate of petitioner number 2, and the legal heir certificate has been applied for, and some more time may be granted to produce the legal heir certificate. The copy of the death certificate of petitioner number 2, which is filed in court today, with a memo is taken on record. Copy has been furnished to the Land Council for the opposite party number 4, so also the State Council. So what time you want? Please.
we have already applied. The 2 weeks time will
Put up this matter after ensuing our petition, let me know the date they for filing the legal heir certificate for consideration of the interim application number, that is IN number 5295 for 2025, for substitution of the so and so. Status quo order passed on 10/3/2025 in IN number 1517 of 2025, in operation till the next week.
Your Lordship, a copy of the petition will be served.
Let a copy of the petition along with all the annexures be supplied the Land Council for the opposite party number 4 in the meantime. Yeah.
Item 13.
I have filed the substitution petition, IN number 4/25. You can answer the case, the petitioner died.
6/8/9.
8/4/2 of 2024.
Who has died?
Petitioner died.
Okay.
I have.
What is the death certificate?
Death certificate, there is no death certificate, legal aid certificate. I have mentioned the date 7/3/2025.
Certificate are the legal aid certificate are the X is the petitioner. You say that X has died and Y and Z are to be substituted. So we must get some documentary evidence about the death as well as that these persons are the legal heirs. Other persons have been left out, who knows? So file those.
I will file. It's not available with me just now.
No, it's all right. We are granting you time.
Yes.
IN number 6842 of 2025. There is an application filed under R22 Rule 4 of the CPC for substitution of the legal heirs of the deceased petitioner who stated to have died on February 7th through 2025. The Land Council for the petitioner seeks some time to produce the copy of the death certificate, so also the legal heir certificate of the petitioner. Put of this matter after summer vacation. Yes.
Item 14.
Yes, Mr. Lanka.
May I please? By order dated 11 of March 2025, the London State Council will take instruction regarding
Instruction received, my lord. Will file the paravis. When the paravis comment received, will file a countermine.
Acha. The London Council for the state submits that he has received the parawise comments. Parawise comments. Stop. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. And counsel for the state accepts notice on behalf of all the parties, all the opposite parties. Therefore, he has received Land Council for the state submit that he has received the parawise comment and he will file the counter affidavit. Put up this matter after summer vacation. Counter affidavit we filed in the meantime, serving a copy on the Land Council for the petitioner. We is at liberty to file the rejoinder affidavit, serving a copy in the Land Council for the state. Yes.
Item 15.
Let's say last occasion, permitted me to file documents which is connecting to the cell deed of present petitioner, namely Banmaliraj. I have already filed cell deed of
Come to the order dated 7/4/25. Have you got the copy of the order?
Yes.
Please place it. You that is lying there, nobody is using it. Seven 4/25 hours.
London Council for the petitioner seeks some time to produce relevant documents in their respect matter.
No.
Part of.
Why are you not placing that order from the beginning?
As per the order dated 17/2025, Knowledge Council for the state has produced the written instruction dated 4/4/2025 received from the Tahsildar Bhubaneswar, wherein it is mentioned that WL case number 162/23 has already been disposed of, sanctioned by the orders of the then Tahsildar, but the date of disposal has not been mentioned in the written instruction. The written instruction is taken on record. In the petition, averment has been taken in paragraph number 3, that the petitioner purchased the land in question by way of a registered cell deed bearing number 8672 dated 19/8/2008 from one Sumitra Behera 1, and in paragraph number 4 of the writ petition it is stated that the vendor Sumitra Behera purchased the land from Sarveshwar Parida by the registered cell deed number 4568 dated 12/6/1981, but the said registered cell deed copy has not been annexed to the writ petition. Moreover, on perusal of the photocopies of the order sheet purported to have been maintained in the WL case number 162/23 annexed to the writ petition as annexure 3, there too at page 45, the name of Sarveshwar Parida finds place as the petitioner in the lease case, whereas at page 46, it is mentioned that sanction of lease is granted in WL case number 1972, which is altogether a different WL case. It is also not clear from the said order sheet as to in which forum the said leave has been granted. Therefore, from the document filed by the petitioner by Annexure 3, it is not clear that in WL case number 72 by 23, lease of the government land was sanctioned in favor of Sarveshwara Parida. Learned counsel for the petitioner seeks some time to produce the relevant documents in that respect. We made a specific query in the order dated 17/3/2025 regarding the number of pending WL cases before the additional Tahsildar Bhubaneswar, and in the written instruction dated 4/4/2025, it appears that a team of office staff has been interested on the supervision of an additional Tahsildar to make to list out such cases. If any, the written instruction is taken on record. Learned counsel for the state seeks some time to produce the updated report in that respect. List is made, sir.
Yes, so what documents you have filed first from your side?
My lordship, shall deed of Sarveshwara Parida,
What is that?
additional affidavit. Copy
Copy
served, my lordship, already list,
additional affidavit filed by the petitioner.
my lordship,
That is dated 2nd May 2025.
my lordship.
So, sir, data reason. You have served a copy in the AG office?
My lordship.
Won't day after tomorrow on to Anand Puseta. The London Council for the. And what about your instruction?
Well, an instruction letter has been issued, but instruction not issued. I'll also obtain the instruction.
Get that instruction. London Council for the petitioner submitted that as per the order dated 7/4/2025, he has filed the additional affidavit on 2/5/2025, annexing the relevant documents. Stop. If further that a copy of the additional affidavit has been served in the AG office. However, the London Council for the state submits that the additional affidavit has not been tagged to the file, and he has also not obtained the instruction as per the order dated 7/4/2025. Regarding the number of pending WL cases before the additional Tahsildar Bhubaneswar. You see this, we wanted to know because these WL cases are of 1972, 73, sometimes it is reported to us that it is not being disposed of, it is pending or this, that. So that is the reason whether this WL cases you are maintaining a register, how many cases are pending. So all this data, once it comes and we can know it. That is why. So
in the letter dated 4/4/2025 issued by the Tahsildar Bhubaneswar, they have mentioned that they have engaged some steps to.
Right, but it should be, you see, there must be a register to that effect. Each case is given a number, and if it is disposed of also, there must be a marking that it is disposed of. And the order copy also, it would be available with you, whether it is in favor of the person or against that, that will also be there. So if that is available, from that you can know that how many cases are pending, which year. So, put up this matter next week, that is 12th of May 2025. Yes.
With pardon, my lordship, my lordship, WL case number 565 apply करथिले तार सर्टिफिकेट कॉपी पे, but additional Tahsildar लिखि दिसंती, it is not presently traceable in the record room member.
ठीक है, अच्छी सी, तो if not traceable, what can be done? Pipes कितने number?
Annexure 10.
No. Annexure, no. Which case number? WL case number?
WL case number 565/72. and fully enforceable.
In that lease case, it was granted in favor of your vendor.
My lord.
So,
But they have engaged some officer to locate it. Let them locate it first.
you are claiming your right, that your vendor has got the land by way of a registered sale deed from Mr. X, who had got the lease.
My lord.
That is your case.
My lord.
So let us say the report comes that there is no such WL case in 1972. Let's say, for example, and they gives the report. Then your entire endeavor that WL case lease was granted in favor of X, from X, Y purchased the land, and from Y, I have purchased the land. So the title goes like this. It goes, so now they have not traced it out. So from the records, at least it would show that whether any such case has been filed or not. Right?
My lord.
72 ମସିହାର ଯଦି ରେକର୍ଡ ଥିବ 565 ଆଉ 1972 ବୋଲି କୌଣସି କେସ୍, ସେଇଥିପାଇଁ ଆମେ କହିଛୁ ଏ କେସ୍ ଗୁଡାକର ଯଦି ରେଜିଷ୍ଟର ମେଣ୍ଟେନ ହଉଛି ତାହେଲେ ଏ କେସ୍ ର ଷ୍ଟାଟସ କ'ଣ, କାରଣ ସିଏ ଆପଣ ଏଇଟାକୁ ଲେଖିଦେଲେ କପି ଆପ୍ଲିକେସନରେ ଆଚ୍ଛା ଏଇଠି ଗୋଟେ ଲାଇନ ଲେଖି ଦିଅନ୍ତୁ. ଦି ଲ୍ୟାଣ୍ଡ କାଉନସିଲ ଫର ଦି ପିଟିସନର submitted that he has applied for certified copy of all the order sheet in WL case number 565 of 1972, by copy application number 2819 dated 19/4/2025, but it has been reported to him under Annexure 10, which is annexed to the additional affidavit, that after thorough search of record section, it was ascertained that the said record is not presently traceable in the record section. The Land Council for the state shall also take specific instruction regarding the availability of WL case number 565 of 1972. Clear? Free copy of the order be handed over to the Land Council.
Relance to the letter dated 4/4/2025 issued by the Tahsildar Bhubaneswar.
4/4/25.
4/4/2025. With reference to the subject cited above, I am to say that one Sarveshwar Parida, son of So, has filed a petition for grant of lease that 1 acre pertaining to plot number 540, khata number 201 of Mouja, Kotapatana, and WL case number so and so was registered. After observing due procedure as per OGLS Act 1962, lease of government land was sanctioned in favor of petitioner by common order passed in WL case number 565 by 1972, as it appears from the order dated 25/7/1973 of the then Tahsildar Bhubaneswar. On the strength of sanction order, ROR was corrected and photo prepared. Note of action for correction of ROR has been noted in the remark column of the order sheet, and necessary order was passed to send the case record to record keeper by the order dated 29/11/1975. It is pertinent to mention here that Honorable High Court Orissa, while disposing the OJC number so and so,
earlier.
Yes, my lord. In its order dated 19/1/1996, has directed state government to inquire into the matter relating to the lease of the land in Bhubaneswar Tahsil through a senior officer in the rank of secretary, and to inquire whether Tahsildar has settled the land by misuse of power. Honorable High Court further in its order dated 15/10/1996 had also directed to government to examine whether the case are covered under 3B of the OGLX Act.
ଏଇ ତ ଗୋଟେ ଫ୍ରଡ୍ ହେଇଥିଲା, ତାପରେ ସବୁ ଗୁଡାକ ରିଓପନ ହେଲା, ସେ ଠିକ ଅଛି। ତ ଏଇ ଯୋଉ ତାର ଲିମିଟେସନ ବି ଥିଲା ସେତେବେଳେ ମାନେ ଇଏରେ, କିନ୍ତୁ ଫ୍ରଡ୍ ପାଇଁ ଲିମିଟେସନ ନାହିଁ ବୋଲି ତାପରେ ଆପଣ ଆମେଣ୍ଡମେଣ୍ଟ କଲେ ସେ ଯୋଉ OGLS Act ର ଯେ ନେସେସରି ପ୍ରୋଭିଜନ। ବଟ୍ ଥିଙ୍ଗ ଇଜ ଦ୍ୟାଟ୍ it appears in record that there is a case, WL case number 565 of 1972, which is mentioned, तार records आसिले जना पड़ियो कौन order टा है
The certified copy मागिले
हाँ,
certified
certified
copy
मागिले
record not traceable.
record traceable नुहे कि record कुआडे गला कौन है इसी तक देखो
In the meantime, my lordship, mutation case number has been allotted to in the name of Sumitra Behera. He has got Jaman of the Satyan number. Already, he has got already Satyan register number, my lordship. Mutation case has already been allowed in the year 1995. In that case, my lordship, noted CR is put up today, petitioner is absent. DL is sanctioned report that WL case number by based by testimony was returned back from the ADM Bhubaneswar by the letter number 5390 dated 19 due to one main lease case.
type ro mane परिचय so reopen hela pare बहुत केस जଣା पड़ुची जे को टाइप रो है so of course the thing is that it was 72 73 से जमी रो किसी माने ये न तो सब बड़ा reopen हला परे सब जଣା पड़ुची जे बहुत ज्यादा है so always get the instruction let's see
Item 17.
Pardon to appear virtually, my lord. I am for the petitioner. The matter related here is the petitioner has challenged the order of the Learned and Administrative Tribunal, Cuttack bench below. Her contention was that she wanted to be converted from CPF to GPF scheme, but it was not accepted by the Learned Court below, and it was disposed of. On the last occasion, my lordship had asked to place the original application and the counter affidavit in an additional affidavit. It has been filed, my lord, and the copy has also been served.
yes who is appealing
Union of
you have
India.
received the additional affidavit
Yes, I
okay. Yes make your submission
My lord, the case, I'll go to the facts of the case. The petitioner is a retired KBS teacher. She was posted in Malappuram, Andhra Pradesh in the year 1985.
you are challenging order dated 21/10/2024
Yes, my lord.
right so that order is annexure 1
yes, my lord.
okay
My lord, slightly interference. I am for opposite party number 1.
yes
Union of India, who is a proforma respondent. So,
what do you want
Kendriya Vidyalaya is here.
no let us see that if the merit is there we will issue notice whether if we find that there is any flaw in the impugned judgment we will issue notice so let him first satisfy that it's a case for issuance of notice or not so yes what is your prayer in the before the Central Administrative Tribunal
Yes, my lord.
are you not ready
No, my lord, I just said. My prayer was before the Central Administrative Tribunal that if I can ask my lord to come to the Annexure 3 of the WPC.
come to the paragraph number 14 the operative paragraph
14 of my lord.
paragraph number 14 internal page 22 running page 34
Yes, my lord.
read it out
We have gone through the decision of the CAT Madras bench in the case of Usha Gopal.
no that is not the paragraph that is paragraph number 13 we are asking you to read paragraph number 14
In the case in hand, admittedly, the OM of the KBS for submission of option came into
My
effect.
lord, in this case, my lord directed to serve a copy. They didn't serve the copy.
Madam
No, I
says that he has received the copy.
No, we didn't have, might have given the state.
No.
Additional affidavit
You are appearing for Union of India.
Union.
So she says that she has received the.
No, it's,
copy of the-
sorry, my lord, it's 18, 17. I am for 18. Yes.
And
You are appearing?
17 item.
No.
No, 18 is something.
We are taking off item number 18. Just a minute.
18 divided, my lord. Just 17.
17
और 17 तो
टका हला 17
हाँ ठीक है जी 17 तो जल्दी कौन हला मिस्टर पारी वी आर इन आइटम नंबर 17 all right yes argue the matter 17
Yes. In the case in hand, admittedly, the OM of the KBS for submission of option came into effect by original OM dated 1/9/1988, and at that time, applicant was continuing as TGT English in KBS at KB Mallapuram, Visakhapatnam, Andhra Pradesh. But for the reasons best known, the authority of the KB Mallapuram, Visakhapatnam has not been made as one of the respondents in this OA. Be that as it may, she continued to discharge the duty as an employee of KBS after issuance of the OM dated 1/9/1988 for a period of 24 years, that is till her retirement on 31/10/2012. Her counterpart employees availed the benefit of the OM dated 1/9/1988 cannot be disputed, and the contention of the applicant was not aware about the same and therefore she did not avail the benefit is unbelievable. It is also an admitted fact that she did not take any step over a period of more than 7 years from the date of her retirement. She was allotted a new CPF account number is not in dispute, and she did not also question at the relevant time the new CPF was allotted to her. It is the specific case of the respondent that at the distant point of time of 30 years, her option form is not transferable. Fact remains that she had never made any representation raising protest or objection for counting her under CPF scheme. Her contributions were regularly being deducted from her salary for years together, and she was also aware of contribution made by her and on behalf of the authority and the annual amounts which the respondents used to supply regularly. While GPF statements were being issued to her counterpart employees who had opted to switch over to GPF pension scheme, and on the basis of statements, applicant had submitted her income tax return for a long period. Similarly, the plea of the applicant that if no option is received by the cutoff date, the employees should be deemed to have come over the pension scheme is also not tenable in the eyes of law, because it did not raise any such objection at the relevant point of time when she was not brought under the GPF scheme, while her counterpart employee were brought over under the scheme on exercise of their option. This shows that this is an afterthought plea taken by the applicant, taking the advantage of non-availability of her option after a period of more than 32 years. Law is well settled that one cannot take the advantage of his or her own wrong jus ex injuria non oritur, as held by the Honorable Apex Court in the case of Lily Thomas versus Union of India Tandar. Further, law is also well settled that one cannot get the benefit in an indirect manner if he or she is not entitled to get the same directly, as held by the Honorable Apex Court in the case of Supertech Limited versus Emerald Court on Resident Welfare Association. Had the applicant produced any such evidence that though she had opted to switch over to GPF pension scheme, the same was not considered, the matter would have been different. The time passer, coupled with the fact of allotment of new CPF account number, deduction of amount from her salary towards CPF contribution yearly statement, payslips, etc., clearly establishes that the applicant remained in the CPF scheme as per her wish, and merely because the original documents relating to option was not produced, that should not be a ground to ignore the ample materials, cannot be a ground to interfere in the matter at this belated stage.
What is the wrong in this?
The wrong is this matter, my lord. The petitioner came to know about this official memorandum through the judgment of the Madras High Court in the year 2019. Thereafter, she filed RTI before the KBS authorities about the option that she has excised. But the KBS authorities were not able to give any data that whether she had excised any option or not. Then she filed another RTI where she had asked about her if anything has been contained in a service book. But there also there was nothing containing that whether she has excised her opinion or not.
The benefit has been mentioned. Your counterpart got the benefit in 1988, and you are not disputing the same. But you are saying that I was not aware about the same.
Yes, my lord. If supposingly, if I have not availed the benefit of being to CPF in by law of the memorandum, I should have naturally come to the GPF scheme. If my lord can come to Annexure 3.
After 7 years of retirement. See, your claim is suffering with latches.
Yes, my lord, because the petitioner was not aware of it. She only got to know about it after she came across the judgment of the Madras High Court in the year 2019. Thereafter, she has raised the question before the KBS authorities and also in various forums. Then only after that, she filed the original application. If my lordship could come to Annexure 3.
So you know that there are on the ground of delay and laches of a party, relief cannot be granted, number of decisions are there. It is a case where on the face of it appears that what are your laches? And your case that I came to know from a Madras High Court judgment that but simultaneously it is stated that how your counterparts have got the benefits.
But it is
and,
also true, my
all
lord,
these things are there.
that the KVS authorities have not been able to show where I have exercised my option to remain in the CPF scheme, because the memorandum says if I have not exercised the remain under the CPF scheme or something, by default I'll come to the GPF scheme. So if I have not exercised anything, then I should have come to the GPF scheme. I have still remained in the CPF scheme, and the KVS authorities are not able to show that where I have exercised my option to remain in the CPF scheme. That is the question, my lord. My lord just can come to Annexure 3. It is proper.
No, the option came into effect in 1988.
Yes, my lord.
Right?
Yes.
So it must have been given to all the employees. Not you cannot say that I was not aware.
No, that is the thing, my lord. The official memorandum was not communicated to me. It should have been communicated to all and each and every employee.
No, come to your least update in the OA which you have filed.
Yes, ma'am.
So you see, you are retired in 2012.
Yes, madam.
And you started giving asking RTI information in 2019.
Yes, madam.
Whereas the Madras High Court, Madras Tribunal has passed the order in June 2020. So therefore, you are saying that you came to know about your right after the Madras High Court, Madras Tribunal's order is wrong. Because in January 2019, you started giving RTI applications.
Yes, my lord, I would have gone to know it through only.
So you have started acting after 5 years after retirement.
Also, my lord, the question.
Not even 5 years, 7 years.
Yes, definitely, my lord. But the official.
See, come to your least update in the additional affidavit which you have filed.
Yes.
See the dates, date chart. June 2020 is the date when the Madras Tribunal passed the order. 3rd June 2020. Madras.
If can bring the attention of my lordship to WPC, point number 7, page 5.
WPC?
WPC number 5, point number 7.
Point number 7.
Yes, point number 7 on the next page, page number 5. Para 7 of the said office memorandum dated 1/9/1988 explicitly states as follows: It is requested that all head office or principal may please bring these orders to the notice of all contributory provident fund beneficiaries serving under them, including those who have retired since 1/1/1986, and to the families covered by Part 5 of this, as well as those who are on long leave or under suspension or have proceeded on deputation or foreign service training from their office. So this official memorandum should have been communicated to me, and the KVS authorities have failed to, so that
How do you say that it has not?
they have not communicated to me.
Ground taken, not informed me, so it's a.
You know, so the dispute would have come if I would have opted for CPF scheme, and then I would have negated that I want to come into the GPF scheme. But in this, the question, I have not opted for anything, and if I have not opted for anything, but default, I should have.
As for the order dated 18/3/2021, the London Council for the petitioner, by way of an additional affidavit, has filed the original application, counter affidavit, rejoinder, reply to the rejoinder as annexure 6, 7, 8, and 9 respectively. Copy of the additional affidavit has been served on the Land Council for the Union of India, Ms. Sangamitra, Mrs. Sangamitra Rajguru. You are the central government council or upon designation?
Senior panel council.
Senior panel council, Union of India. Hello? Hard argument, order reserved.
Your Lordship, if my senior may come on the next day, argue.
Next, yes.
Item 18. Land acquisition compulsion not properly made to the petitioner till that matter. Therefore, humbly praise before my Lordship for granting of compensation amount. My Lord, Paradip Hardaspur Paradip Railway Rings project already done over the Halpat number 1579 Hal Khata number 567. The one person.
No, your case is that if you have received the compensation amount and you, if it is according to you that it is at a lower side, you are entitled.
Given to the petitioner to till death.
No, what we are pointing out to you that there are alternative remedy available with you not to file the petition. If you are not satisfied with the amount of compensation that has been paid and received by you, maybe under protest or whatever it may be. So if you have alternative remedy, why we will entertain this petition? That's the question we are asking to you. Suppose you say that for a particular part of the land which has been acquired also, you have not been paid, or the amount which has been paid to you, that is also on the lower side. So you can approach the forum is available with you. There are alternative remedy.
Regarding this matter, my Lord, the petitioner already filed one written application in the year 2023, bearing case number 10896/23. Already disposed of 27/2023. And according to that representation, and the department already given under annexure 3, kindly have it answered under annexure 3.
This is the matter against the railway. Last year, my Lordship had the copies for the railway. Right, already.
No, the Mr. Party is there, so.
Copy, I am having also copy.
Have you not solved a copy?
No, madam.
Right?
Lordship, on last date, I have not.
I didn't receive. LMS will got it and send it by instruction, my Lord. But let them serve a copy. Official record.
The London Council for the petitioner took some time to serve a copy of the writ petition on the Land Dept General or Union of India, put up this matter on such and such date, along with all the enclosures for the copy of the petition along with the enclosures. Okay.
Item 19.
Yes, Mr. Samantra.
You can see last of the not very you look to direct it or against status of the case.
We seek some more time to, we are sending the letter.
What is this Annexure 3?
Annexure letter issued by the special to government. Direct.
Submission of calculation sheet copy of so and so. वो sanction ପାଇଁ ପାওয়া और 9/8/2024 ହେଲାଣି जो आपन कहले sanction ହେଲା कि नहीं
I saw more time.
All right, the Learning Council for the state seeks some more time to obtain instruction as per the order dated 9/4/2025. Put up this matter after summer vacation. Yes.
Item 20.
Yes, Mishra.
Here, all the petitioners are landless persons and they are staying. Staying in the vacant land of the government at Homicidal. Considering their prolonged possession, a survey was conducted and they have also been issued with the house numbers that Annexure 6 series will also get. The house numbers they have been given. They are staying there. All facilities have also been given to them. That is road, Anganwadi center, electricity, everything has been communicated to that particular land. But that land has not been settled in their favor. Prior to this petition, from the occupant of that area, they had approached this honorable court in another petition that is that I have annexed, that is WPC 6573 of 2023. Lots will get at Annexure 8, page 52. There, my lord, the direction was to approve the Consolidated for the by submitting a fresh representation. And they also submitted the representation and steps have been taken to settle a small piece of land in their favor. Small piece, 200 to 300 square feet of land. They have decided to give. So far, the petitions were not party in that petition, their cases have not been considered. So may I pray one thing, my lord, will submit a representation before the opposite party number 4, ventilating out grievance.
No, status code will not pass. We do not know EDC of that. What is the
or my lord may take instruction.
What instruction?
About the survey, they have already, the municipality have already
filed your representation in accordance. No
Yes.
question of passing the status code.
No, my lord, only representation. Because they are not going
So
to
this application has been made by the petitioner for a direction to the opposite party to settle allot lease out the land under occupation of the petitioner in their favor, taking into account their prolonged possession. The
settlement there is a specific format is there.
and to dispose of the representation submitted by the petitioner by the opposite party number 2. But after arguing for some time, the Land Council for the petitioner submits that the petitioner will apply for the settlement of the land in appropriate format under the OGLS Act, and therefore he seeks permission to withdraw the petition
before the opposite party number 4 years.
Opposite party number 4. Opposite party number 4 to 3. The petition is disposed of as withdrawn. Yes.
Not to only observe that if such application is made, that may
Yes, next.
Item 21.
Annexure 21, man, it will not be called it after application. Because on the last occasion, you lost
The model count pass Any interim order has been passed?
No, madam, no.
Acha, learned counsel for the
I have
petition.
applied under RTR
Six for an adjournment to obtain instruction, necessary instruction, as per the order dated 11/4/2025. Now put up this matter after ensuing summer vacation. Yes.
Item 22.
I read 22, 23, 24. I think we can pass over. Summer is another.
Yes. That's
Item 25.
My please, madam. Well, with the second round of litigation, earlier writ application was withdrawn by the petitioner, so that the government will consider the case.
Why have you withdrawn?
My lord, that the government will consider his case for keeping in that view, my lord. The writ petition was.
Where is the order passed?
My lord, that has my lord, has annexed, my lord.
You have not annexed.
Annexed, my lord.
What is the annexure?
Page 56, my lord. Page 50, running page 56, my lord. Simply withdrawn, my lord. Order dated 21/6/2013, my lord.
Just a minute. 56.
My lord, running page 56. This is the Honorable High Court order.
So if you have not taken liberty to file the another writ petition, why will allow this writ petition? A writ petition has been filed for seeking some relief that has been withdrawn. Law is well settled that if you are not taking liberty to file the writ petition, then you cannot, the court should not entertain the second writ petition. Are you aware about that proposition or law? Without seeking for liberty, if you simply withdraw on the self-same cause of action, you cannot file another writ petition.
Under 2013, my lord, that's
If you are not aware, please go through this. If you have not taken liberty of the court to file, that is why it is said that if you want to withdraw the writ petition, suppose there is some more documents you want and you want to file a better application with detailed particulars, for that you withdraw it seeking liberty, so that liberty will be granted. But this is the order in which no liberty has been granted.
My lord, that is my lord, lordship, my lord. For limited grievance of the petitioner, my lord, that is the representation which is filed pending and correspondent made, my lord, that may be considered, that is the limited grievance there, and also, my lord, the writ application. The fact of the case, your lordship permission, I am saying, my lord.
No, here will not go through that unless you overcome that past order.
Past order, that is the only written, my lord, permitted to withdraw. Simply withdraw.
We are posing you a legal question.
My lord.
That same prayer which you made in the earlier writ petition, you have withdrawn it. Can you file another writ petition? You have not taken liberty of this court to file another writ petition. That is the fundamental thing.
My lordship, my lord, I will verify, my lord. So for my
writ petition has been filed by the petitioner Kiran Kumar Khan.
observation simply satisfy say point.
No, how can we know that Kanun go? Try to meet the point.
My lord.
Don't hesitate. Search out the decisions on this.
My lord, I'll search. Simply
No, we will indicate it. Kiran Kumar Kanungo has approved this court for some reliefs. It appears that for same relief, the petitioner earlier filed the writ petition bearing WPC number. Which is that WPC?
That is WPC number, my lord. WPC number
26814 of 2011, which was disposed of on 21/6/2015 with the following order. Pura court order. It means that no liberty has been granted to the petitioner to file another writ petition. Let the learned counsel for the petitioner examine as to whether this writ petition would be maintainable under the self-same prayer or self-same prayer when earlier writ petition was disposed of as withdrawn. Put up this matter after summer vacation. Where is the research assistants? Where have they gone?
Item 26.
Very bad of mine. And in this case, petitioner getting challenged with the maintainability of OEA revision, the review petition dated in this case by 303 of 2024 by the annexure 1 madam. On the recommendation of the collector Kendujal, the learned member of Board of Revenue settled the case land in the name of the opposite party petitioner deity in the year of 1985. After 41 years of settlement, the learned collector, present collector, recommended by a bias of the one private persons, the recommendation of the collector is
What you are challenging here?
My lord?
What you are challenging?
I will challenge, my lord. The review petition is not maintainable before the member of Board of Revenue after 41 years.
Where is the order?
My lord, proceeding is pending.
In that proceeding, he has already taken part, and that matter is pending for disposal. He appeared there.
And raise the point of maintainability there.
My lord, after 41 years.
Maybe you raise that point.
For that purpose, he's asking time. And my lordship may come to page number 46. Learned Standing Council appears on behalf of the state as petition advocate for opposition is present.
Have you raised the point of maintainability?
Raised for 10 days time to file his written note of submission.
No?
My lord, my response submission, the annexure 3 is a limitation petition filed by the collector Kendujal. The law
file your objection to that.
No, objection file karchi.
There will be adjudication on.
My lord, annexure 3 hochi.
No, when it is being before one authority and you have not raised any point, why will you pass that initiation?
Annex the entire order sheet. Let
the revenue board pass an order.
First limitation karibe, limitations conventionally like merit showing.
I'll do that.
OEA case number 62 of 1985.
OEA revision.
Huh?
OEA case, OEA revision.
OEA case number?
OEA revision.
OEA revision case number 62 of 1985.
My lord.
Judgment dated 3/10/1985. Stop. The learned counsel for the petitioner submits that such a revision petition has been filed after kete years Kuchanji?
41 years.
41 years.
Revision file, review
Review has been filed after 41 years. And therefore, it should not have been entertained. But it appears that the state has filed an application for condonation of delay, and the petitioner is taking time to file objection to the said petition. Since the matter is sub judice before the which authority it is sub judice now?
Member Board of Revenue.
Member Board of Revenue, and the petitioner is at liberty to raise all the points. We are not inclined to accept the prayer made in petition. Accordingly, writ petition stands dismissed.
My resolution, my lord, I annex entire order sheet. Se kono se order sheet ka limitation ta use consider karunati. We bypass the limitation.
Next.
No, my lord, directed to fact consider.
Item 27.
It's up to you to raise that point. That
Already raised, my lord. My maintainability petition by the annexer 2, my lord.
Yes, sir.
But of the entire order sheet shows from the beginning, before notice, they decide.
The petitioner is at liberty to raise the point of maintainability of the review petition, which will be considered in accordance with law. Yes.
Item 27.
Live streaming top.
Item 27.
Yes, item 27. Yes, you have to take
on 30th.
What is your instruction?
On 30/4/2025, we have received the instruction wherein it has been stated that he was asked to produce certain documents, not be produced. Therefore, the order of land civils will not be implemented. That is, and the notice, everything has been annexed.
You see, you are not filing any application. There is a judicial order passed by this court in WPC number so and so, and the operative portion of that order reads as follows: that paragraph number 4, considering the submission made and without expressing any opinion on the merits of the case, this court disposes of the writ petition, directing the opposite party number 3 to dispose of LR case number so and so in accordance with law within a period of 3 months from the date of production of the certified copy of the order, and communicate the result of such exercise to the petitioner. It's further directed that in case the application of the petitioner under section 28A land acquisition is allowed, and if there is no legal impediment, the compensation amount to be disbursed in favor of the petitioner. So clear cut order, there is no.
No, what you are saying is, since the applicants are not appearing, so therefore it can't be heard. But you should have sought time for extension of time. It could not be done. Please extend the time.
The authority has said because of that legal impediment, we are not able to.
No, you can't simply say that it can't be done.
Once you receive the copy of the order, which is obviously has been served by the petitioner, then the time limit starts. You have to dispose of the. So for some reason, suppose you are unable to dispose of it within that 3 months, then it required on your part to file an interim application before this court in that dispose of writ petition to extend the time, putting forth your grievances or whatever difficulty you are facing, but you are not seeking for any time
because the petitioner himself is not cooperating. That
no,
That's a different story.
But yes,
if they are not cooperating, dismiss it. Dismiss their petition.
because of
That's your problem.
we are
That's your problem.
we are on a limited point. We are
because of the court not neither dismissing now. They are also asking again and again. Again, it should notice. It should notice to the.
Who is the counsel for the petitioner? He is also not there. Srikant Mahanto, Vijay Kumar Behera. Arjun
You file.
The learned counsel for the state has received the written instruction from the special LA and ROR, our lawyer Indra Irrigation Project Career.
We can drop the contempt because there can't be contempt. In one hand, it takes the order.
Follows for the entire portion. From which it appears that how for the laches on the part of the petitioner, the LAR case, which was supposed to be disposed of, LAR case number 65 of 2017, which was supposed to be disposed of within a specified period, could not be disposed of. The written instruction is taken on record, the contempt petition is dropped.
Since
there is no willful disobedience on the part the opposite party contemner. Hello? Opposite party number 2 na eta? Ye deichendi eta Kallu Maji to?
Age, Kallu.
Opposite party number 2 contemner. We are just coming with it.
Item 28.
Last token was the direct to file additional affidavit regarding receipt the certified copy of the opposite party matter. Flag A my additional affidavit for example, the document which has issued after receipt the court order matter, they issued the notice to appear matter.
Bill, just a minute. ये नंबर टा रीड पिटिशन नंबर टा मेंशन है जी नोटिस है
मैं
कितना नंबर है
मेंशन करा
अब किसी नंबर टा कितना
26,312 मैटर 26312 मैटर
अच्छा
सेकंड पिटिशन को नाम लिखा है
जस्ट
7 serial number 7 जगबंधु देव
7
मैटर
as per the order dated 18/3/2025, the London Council for the petitioner has filed an additional affidavit which would show that he has served the copy of the order of this court dated 2/5/2024 passed in WPC number 26313 of 2019 on 15/5/2024 on the opposite party contemner. It is further stated that after receipt of the same, the opposite party contemner issued notice to the petitioner on 2/8/2024, fixing the date of hearing to 12/8/2024, and the notice has been annexed to the additional affidavit. Let the London Council for the State obtain instruction. Issue notice to the opposite party requisites for issuance of notice by report with proof of delivery be filed during by Friday. You filed this one. Okay. Put up this matter after some partition. Yes.
Item 29.
You have taken time.
On 25/3/2026, 25, my lord, he has asked for 6 weeks time to comply the order.
No, in that way, no. You comply the order. If you cannot, because that happened in many first contempt, second contempt, you are to comply the order. You are seeking time, will grant, but there should not be any further contempt. You will not grant again. You will say, sir, you disposed of the first contempt.
Your lordship, keep it pending, my lord.
So where is that letter?
Yes.
let it come to verification, genuinity of the, it's all right, whatever it is, you want and finish it. Again, so dispose of it. It's not that we'll grant again, dispose of again, again, he'll come. It also 25 रो and 25 रे 6 सप्ताह आपण मागिथिले 6 सप्ताह तो पड़िलानी 25 ने ही ने
The initial order is for 3 months.
Well, on the very same day, that was according to the verification, it is found.
No. आपण 6 सप्ताह मागुछन तो 25 दिन रो कैलेंडर को we'll count it from 25 दिन also. So 1 2 3 4 5 and May 6 रे माने आसंता काली 6 सप्ताह हे जो so take time, take instruction, we'll talk taking of the matter
Well, in this case, what is happening, the land action officer is, after calculation, is sending the file to the director. Director sitting over the matter for long.
We do not know, it is just a, you see the order, what is the order? The order is just to, what is that order? Application filed by the, under Annexure 3, pass appropriate order, that's all the order.
Take a decision on the application.
Take decision.
Decision नहीं है.
That's your very decision यही नहीं पड़ा. Look, the Land Council for the state has produced the letter dated 25/3/2025 of the Spesa Lele and RRO, Lower Indra Irrigation Project Khariar. 25 दिन लिख दो, wherein it is mentioned that 6 weeks more time be allowed for disposal of the case. Disposal of disposal of the application filed by the petition. Since 6 is going to be completed tomorrow, put up this matter day after tomorrow. The Learning Council for the state shall apprise this court.
Can it be
about
Thursday, Miller?
Yeah?
Can it be on Thursday?
Acha, Thursday for me. Please this matter on 8th of May 2025. The Land Council for the state shall apprise this court about compliance of the order dated 3/10/2024 passed in WPC number 24517 of 2024. And this is taken on record for the right. Rate of the year very good. Carefully of Marble or type paper marble. Yes.
Item 30.
Mr. Samudra. Same, acha. सब it is terminated instruction
31 also
31 32
32 compliant
32 टा compliant अच्छा 30 जैसे कि dictation में
31
तब कोई दो 30 और 31 सेम ऑर्डर कर देबे मतलब list this matter along with so and so कर दें और 32 टा
compliant
the Land Council for the petition of submit that's in the order as dated 8/9/2024 passed in WPC number last item
last item
5
already sanctioned the matter.
just a minute. Order order dated P10/2024 passed in WPC number 24513 of 2024 has been complied with. He does not want to praise this contempt petition according to contempt petition.
29, 30, 31, all will come on 8.
Yes.
Item 33.
May I please? My lord, in this case,
Item 34, a case of child mallet office would not trace out the file.
Which file?
Item 43.
Read appeal files.
Mallet. Next week mallet
2015
or tomorrow?
No, it must trace out the file
Mallet.
because first you have to trace out, then you have to, because it is to be disposed of on merit. So you have to prepare yourself. Now the file is not with you. So we are taking up this matter next week. You trace out the file first and get yourself ready.
There are 2, 3, 4 cases.
There are a number of cases.
if your lordship will permit me,
Yeah.
then my case is squarely covered by the decision of this Honorable Court.
No, let
That's
him.
why I'm giving the decisions today and let it come in the next week. I'm giving the also solving the.
And if not available, please take it in your pen drive also. That will be, and the decision which Mr. Jena is giving to you to see that it is covered.
Court and I'm also serving.
The ଗୋଟେ ରିଟ୍ ପିଲେ ଲେଖି ଦିଅନ୍ତୁ ଫାଷ୍ଟରେ WA number 751 of 2015. The Land and Council for the state submits that the file is not traceable. We are writing it that the file is not traceable in the AG office, and he may be permitted to take the soft copy of this writ appeal along with the connected writ appeal in his pen drive. Permission is granted. Stop. Mr. Jena, Land Council appearing for the appellant submits that
the claim of compensation.
The claim of the appellant is covered in the decision by the decision of this court in case of Swanso reported in Swanso. Copies of the judgments have been handed over to the who wants to take some time to verify the records. So also the judgments put up this matter on 12th of May 22. Yes. It will come on 12th, Mr. Yes, yeah. 12/5. Acha, this will come along with writ appeal number Swanso. You think
Item 34.
Yes, Mr. Rao.
Yes. This is the matter where the field cover documents were
The
kept
reports
and
of settlement revision case number also Swanso just kept in with registered as for the auditor we produce on the next day. Yes.
Well, I have filed the present writ application.
Yes.
Against the direction of the OA was dismissed and I'm before this honorable court. The direction was to imposing punishment on me on the ground that as a while working as a judicial officer, I have committed some mistakes for which disciplinary proceeding was initiated.
You are an IS.
I'm an IS, senior IS officer, and I was posted as Land Reforms Commissioner in 1998-99, and I have passed some orders at that time. And after I retired,
what is the nature of order?
What was one of the increments were stopped. Increments were stopped.
Whose increment was stopped?
Page 23.
No. What sort of order you passed? We want to know in those records for which the disciplinary proceeding was instituted.
Yes, sir. There are the orders for which.
Just tell us. We'll see that. Just tell us. Give us idea.
What has happened?
Yes.
In 5 cases, in 5 regional cases, the charge was
that I have reviewed those orders which were passed earlier as a commissioner without an application being there and condoning the delay and all those things. And in one case, I also antedated the order.
Okay.
So, and therefore, your lordship wanted to see the records itself.
Okay.
In the records, as your lordship will find, that none of the cases were taken up suo motu. They were on the basis of the application. So,
These are the quasi-judicial orders.
Quasi-judicial order. So, in quasi-judicial orders, on the basis of an application filed by each of the petitioners in different cases, I have disposed of that. State has not gone in appeal against that. And some of the cases were also, my orders were confirmed by this Honorable Court also subsequently. And at that stage, when just before my retirement, or immediately after my retirement, a so-called notice was issued to me saying that you have disposed of while working as a commissioner, land reforms commissioner, these cases which against the interest of the state. Therefore,
the quasi-judicial order which you have passed, whether an appeal provides against those orders.
And some requisitions were there, and the requisitions were also confirmed, and my orders were confirmed.
No, question is that suppose, let us say, you have not done it suo motu, that goes to the crux of the matter.
Right.
On the application file, suppose it is an illegal order. But can that be a subject matter of the disciplinary proceeding, particularly when
that is my
If it is an appealable order, it can't be.
No. They are the reviews may not, therefore writ petitions were filed. May not be.
No, maybe. Judicially, it was scrutinized and upheld. The orders are upheld.
Some in two cases it was upheld, and in inquiry in one case,
filed your counter affidavit. Who is supposed to file the counter?
State has to file counter. Union has filed their.
Both have filed. Union have already filed counter.
Pleading complete, Mr. Rao?
Yes, pleading was complete.
Where is that counter affidavit? We do not find here. Memo of appearance, IN number so and so, memo of appearance. Where is the counter affidavit?
Of union government is there.
No, in our board there is nothing about.
State has not filed the counter.
No, that is not.
Union has filed counter affidavit by online mail on 28 October.
No, that is the counter affidavit in way number. Have you filed in this writ petition, Mr.
Yes, in the writ petition.
On 28th October.
No, it was on 12/2/25 you have filed. 12/2.
Just a minute. Let us know from the. First of all, we want to know from the state. Have you filed any counter affidavit? No. That's not filed. Not filed. Okay. And Union of India have filed the counter affidavit on what date?
28th October, ma'am. What is October?
October
2024.
And you have received the copy?
I have received copy on 12th February.
4th?
12th February. 1-2.
4th February 12th February 2025. Okay. Have you filed any rejoinder?
No, I have
not. No, Acha. Counter affidavit. So state has nothing to do. State is not interested.
State is the main contest on the recommendation of the state government.
You are the main person.
Yes, sir.
So
Proceeding in
it is uncontroverted. Whatever he says, if you not file the counter affidavit.
Today I pray 2 weeks time will take instruction there and to file.
And it's a 2019 matter. Notice must have been issued much.
Yes.
21.
What Union of India say that if you are the main contesting party and you will not file the counter affidavit, consequence is likely to follow if it is not controverted.
I pray, Lordship, only 2 weeks time.
All right, Mr. S.S. Rao and Senior Advocate is present for the opposite petitioner. The Land Council for the Union of India, Mr. Bhokta. You are the, Mr. Bhokta is the Central Government Council or
CGC.
Senior Panel Council? Or
No merit, Central Government Council.
Central Government Council submits that counter affidavit has already been filed by the Union of India on 28/10/2024. Stop. Mr. Rahul and senior advocate submit that he has received the copy of the counter affidavit filed by the Union of India. Stop. The counter affidavit has not been placed on record. Stop. Let the same be placed on record. Stop. It appears that the state has not filed any counter affidavit. The London Council for the state seeks some time to obtain instruction as to whether it intends to file any affidavit or not. Put up this matter in the week commencing from such and such date. The go to first week touch the summer vacation, second week session. Counter affidavit, if any, be filed in the meantime by state of Orissa. It is made clear that no further adjournments shall be granted to the state for filing any counter affidavit. If the counter affidavit is filed by the state and copy is served on the land council for the petitioner, is at liberty to file the rejoinder to the state affidavit, state counter affidavit, and also to the counter affidavit filed by the Union of India. In the meantime, serving copy on the respective party. Yeah.
Item 35.
Next, the 8 is to include the order of the learned single judge is under challenge. May I please take the-
You come to the order dated 16/7/24.
16/7/24.
Please read it out.
Madam, Mr. Mohan, the learned advocate appears on behalf of the appellant. He submits his client has preferred appeal against the order dated 14 January 2020 made by the learned single judge in dismissing his writ petition seeking interference to direct his client getting compassionate appointment. Mr. Mishra, learned advocate, additional government advocate, government appears on behalf of state. Mr. Boral, learned advocate, appears on behalf of opposition of 2 to 5 and praise adjournment. We find view taken was the appellant is stopped from claiming compassionate appointment because his father had sanctioned for retirement of specific conditions that no benefit under rehabilitation assistance will be given to his legal heir. List is 2nd August 2024.
So this is the, perhaps that was the given, that undertaking must have been given.
Yes, that
was
is page 52.
Huh?
That is the annexure of the B by 1. That's
Annexure
counter-
B by 1.
Madam.
Counter. Breaking. Post facto sanction is recorded for retirement and relief.
No rehabilitation.
So and so, so and so, so and so, subject to the condition
Madam,
that no rehabilitation assistance scheme for employment of his legal heir
will be allowed
for.
or be present.
Yeah.
Or be present. That's what is important.
No. Suppose on this particular condition, the retirement has been given, the sanction retirement has been given. So how can you seek afterwards? This was in 1997. When you,
Rehabilitation, the very nature of rehabilitation is the immediate. Immediate. Merely it is written not for the present doesn't mean that you will keep on doing it up
That
to
is your lordship in case of leave, if your lordship.
And my lord, DY1 also, OCA rules. That annexed to DY1. Clause
Yes.
5.
DY1
5. Clause 5.
The family of a government servant who has sought for
retirement on the ground of invalidness within the last 5 years of his service before the date of his normal superannuation shall not be eligible for rehabilitation employment under this case.
No.
याद कौन था ये भी तरफ चाहिए The case of the petitioner comes within this category.
Invalidness.
Or invalidness fine say was sought for retirement on the ground of invalidness within 5 years of the his service before the date of normal superannuation shall not be eligible for the sponsor. So keeping in view this, the have also stated that no, I will not claim, and accordingly the order was passed that you are allowed or sanctioned that to take the retirement, and with that you will not claim any. How can you go back? How you will claim now?
What happens, your lordship? My father was classed for employee Orissa Lift Irrigation Corporation. All those employees, those who were given retirement on invalidation ground or compassionate ground, did not take your lordship. So one list was prepared. And in that list, your lordship, there is a condition that whenever any vacancy comes, you will be given appointment. For that, in each and every retirement notice, there is a term and condition that for present, no compensation appointment will be given for the present. All in all, that for that I have also, that is on record. I have annexed other documents, other employees, those who retired, the same income. Then your lordship, what happened? Others were given in the list. I have attached that list, but only 4.
What is that list? Let us see.
List minus. With your lordship.
That condition you are
minus. That is your lordship. Kindly see.
Annexure.
That is. But read petition page 40. Your lordship will see. Running page 40. List of applicants.
Just a minute.
Did my lordship get it? Page 40. Thereafter, your lordship come page 41, where my name finds place. MD Ridwan. Serial number 34. Did my lordship get it?
Yes.
And in the column, your lordship kindly see, those from serial number 28 to 36 to be considered. They have not refuted. That is one thing, to be considered, because whenever vacancy comes, my case should be considered. And
no, here invalidation means what?
Invalidation means you will be permanently incapacitated to discharge the duty.
Then how you will be given rehab?
No, that is your lordship. These are the legal heir. That is employee son. My father was declared invalidation. Then I am the son. Son has before your lordship has come to your lordship.
No, the list of the applicants एठी जो ना गुड़ाक अच्छी, it was the employee himself तांको ना अच्छी ना, जो गुड़ाको employee थिले, से मानो it is not the name of the legal heirs.
No, my lordship that
लेखा इस बड़ा लक्ष्मण लाला पियोनो, अम्मो पियोनो इस.
No, that is your lordship. MD 34 your lordship analysis.
हमें अपन 40 देखो जन तो.
Page
40 and 41.
41 where my name is.
It's all right. So ये जो ना गुड़ाको रही ची, ये मानो को माने retirement करागला on the ground of invalidation, right?
ये अगर टिकट से टिकट serial number 34 रे टिकट देखो.
What is your age now? What is your age now? You are cross 50.
40 somewhat.
No. 2013 you filed the writ petition. That time your age was 39. Today you must be more than 50.
But your lordship continues cause of action because I have.
What?
Your lordship kindly see MD Rizwan, son of Abdul Hanan, ex-mechanic. My other's name is Abdul Hanan. I am the petitioner, MD Rizwan. Am I clear, your lordship?
Yes.
My lord. Now, your lordship, second point, that is when your lordship can see up to 27 appointment was given. Serial number 27. But serial number 28 to 36, they are to be considered. Thereafter, your lordship, up to serial number 30, they have given appointment. Even those who come to this court and file the representation, this court has given direction to.
No, we have no material before us that for in the case of other applicants whose name, as you said, from 1 to 20, that they have also given undertaking like that, that we will not claim any rehabilitation, as has been done in this case. That what is that order you showed?
My lord, report that.
Page 40, na?
No, C by 1.
C by 1.
B by 1.
B by 1 रे एटी जेमती ऑर्डर पास ହେଇଛି जे से जो 1 नंबर रु 26 नंबर जो मानकर सीरियल थिला से लिस्ट रे से मानकर भी एई प्रकार ऑर्डर पास ହେଇଛି एवं ता सत्ते मध्य semanku rehabilitation karagala. So that material is not with what is stated before. It may be that that condition was not there. That is how they were
that
given.
Is your lordship kind of see.
कारण एठी जोड़ाको to be considered जोड़ाको लिखा ହେଇଛି सेगुड़ाकर एई टाइप रो कंडीशन थिबो जम ताकू रखि देले परु एवं जो माने कर क्लीन थिला माने खाली इनवैलिडेशन ग्राउंड रे जाई जंदी से मानकर लीगल एयर्स मानकू दिया जाई
नेक्स्ट 9 पेज 85 ता जान with your lordship permission. Post facto sanction is hereby accorded for retirement and relief of MD Jolly, pump driver of LD Division Cutter, with effect from 1/8/1997, who has been declared incapacitated by the Chief District Medical Officer Cutter for further service. No rehabilitation assistance scheme for employment of his legal heir will be allowed for the present. This same condition. In my case, my lord, page 85.
This is in regard to whom?
That is in respect of your lordship, another similarly present MD Jolly. Mine, his serial number, your lordship, kindly see.
When he applied, when he got.
Your lordship, his name is serial number 35. Your lordship, that list. And 34, he is in 35.
Well, when he got it, when he applied, what was his age? What is your age?
With your lordship, when I applied, he also applied. Your lordship, at the same time, one list was prepared. Your lordship, kindly, his serial number is in serial number 35. Mine is 34.
MD Jalil लो ना से लिस्ट अछि
आया 30
तारो याकू दिया गला की
आया MD Jalil
35
पेज
तारो पुना MD Shakil
पेज
41
I am in 34, so he is in 35.
34 41
काउंटर
नहीं पेन नहीं सीधी मेन रेट petition रो
मेन रेट petition
41 रो
एटा अच्छा
MD देखो 34 ततळे उठछ MD Saki सेटा देखो
to be considered by that.
My lord, to be given. Amar that sir.
What is that law, the document that he was given that?
My lord,
he has already been given.
He already been given.
Where is his appointment?
That is in the body of the petition, and they have not disputed, your lordship. In the counter, they have not disputed or denied the same.
How have you distinguished between this 34 and 35? That's the only case, yes.
And
that's the only, let him. What he says is 34, his case, and 35, Muhammad Sakil's case are exactly similar, with a similar condition. But you have given to 35, not to 34. That's what his case.
Earlier they are approaching this honorable court by double piece number.
Ki?
That petitioner has approached this also. And my lordship has glanced to page 83 of the impeaching order.
So you appointment को paragraph नहीं चलती जो मोहम्मद शकील को अपॉइंटमेंट दिया गला बोली तो जो कि होता बापा जो जलील जो को क्वेश्चन जलील ला हला annexure 9
annexure सेटा paragraph 18 of the read petition your lordship page 20.
But they recently a week back you had a policy regarding this.
That is the litigation or that.
No, entire for entire state you had a policy. There is policy with the family. Policy
death rehabilitation.
There is a fresh policy. If you are covered under the fresh policy, let them consider. There is some policy within last week or last week.
Yes, last week or Supreme Court or
yes.
So you take that
instruction whether he is covered or not. If he is covered, then
another point
the Learning Council for the state during hearing of the petition submitted that policy has been formulated by the state government to give appointment under the rehabilitation assistance scheme and the matter may be taken up after ensuing summer vacation to apprise this court as to whether the petitioner can get some relief or not put up this matter after ensuing summer vacation. Yes. Summer vacation first week touch her.
Pardon to mention, my lord, and jail appeal number 137/24. The appellant was aged about 70 years old. As per NALSA termination report. Yes. Connected appeal, sir, mentioned.
An interim application has been filed for bail in CRLA number 970 of 2024. The petitioner or appellant is in custody since 13/1/2040. Give it to me.
Weekly list, item number 1.
May I please allow? The appellant has been convicted under section 302, 452, under section 452 and 506 of the IPC, my lord. And on a trial court sentenced him to undergo imprisonment for life and to pay a fine of 10,000 for the offence 302 of the IPC, my lord.
For the trial court report, interim application for bail and sterilization of fine to be considered after receipt of the trial court report. In the meantime, the Learning Council for the appellant shall supply the position copies of all the. Now you have supplied it or annexed is and annexures.
Yes.
All right, yeah. Mr. Nayak, the deposition copy देइजन तो annexure 2 series लिखा है तो मुझे इतने बचा दिया.
Smile.
अजी तो छड़ लो. Next.
Item 2.
RI for life malor.
302 case.
And 10,000 rupees in deposit.
Same order. Admit.
Copy nahi.
Deposition copies to be supplied in the meantime.
My preference, Chairman.
Yes. Yeah.
Item 3.
My lord directed to obtain the custody certificate.
Which order we passed the call for the custody certificate?
If a letter has been issued.
Acha, no, it's all right. You have issued letter, but there is no order to that effect. As we find, I don't know whether ସେମିତି କିଛି order ଅଛି କି custody certificate produce କରିବା ପାଇଁ କାରଣ last order ଥିଲା 2013 ର ତାପରେ ଦେଖିଲଣି ଫାଇଲ ଦେଖିଲଣି ତ ହଁ तेईस 10/2013 ଉପରେ ଆଉ କୌଣସି ଅର୍ଡର ଅଛି ନାହିଁ ତ ଠିକ ଦିଅନ୍ତୁ
ଥରେ ଲିଷ୍ଟ ହେଇଥିଲା ସେଦିନ
ଠିକ ଅଛି ମଗେଇ ଦେଇଛନ୍ତି ବେଲାଙ୍କୁ ତ the
15 years but it is case of double murder case of double murder double murder PW 345 are eyewitness to the occurrence.
We are granting interim bail. We are not granting unmarried. You cannot keep the people for 15.
What is the age of the
Now 50.
accused?
Now he might be of 50 years old.
50.
During 2011, 35. Now 15 years of
There are eyewitnesses to your friend. Who are the eyewitnesses?
3, 4 and 5.
Is the doctor?
He wrote 15.
Listen, in view of the eyewitnesses, this evidence of the eyewitnesses, PW3, 4 and PW5, coupled with the medical evidence produced by PW15, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody for more than 15 years, as would be evident from the custody certificate produced by the Land Council for the state. We are inclined to release, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activities, and violation of any terms and conditions shall entail cancellation.
same basic communicated through register.
The order be communicated to the jail superintendent by the through the the order be sent to the trial court by the registered judicial, who in turn shall forward it to the concerned jail superintendent for intimation. 20,000 to 150. Yes, next.
Item 4.
Prisoner's petition has come for engagement of Mr. R. Vishwal, Raghunath Vishwal. Prisoner's petition, another prisoner's petition has come for engagement of Mr. Devaki Marandi. So, which one is the latest one? Gote hochi L re, gote hochi M re. M ta hochi 2023 ର ଆଉ L ଟା ହଉଛି 2020 so এটা সেমটা ক্যারি আউট করব সেই আচ্ছা রেপো কি ম্যারেন্ডি কিଏ advocate চিনଛନ୍ତି
ସେ ସବଷ୍ଟିଟ୍ୟୁସନ ଜେନାଙ୍କ ଜୁନିୟର
ବଡ ଭଲ କୋନ
ଲାଷ୍ଟ ଟାଇମ ବି କହିଥିଲେ ସେ ଆସିଥିଲେ
ମ୍ୟାଟର
ଆଉ ଟିକେ ଖବର ଦେଇ ହବ ଯଦି କାରଣ ଓକାଲତନାମାଟା ଫାଇଲ କରିବେ ସିଏ ସେ ଓକାଲତନାମା ଆପଣ ପଠେଇଛନ୍ତି ଓକାଲତନାମା ଦେଖିବେ ଖାଲି ଚିଠିଟା ପଠଉଛନ୍ତି ହଁ ପଠେଇଛନ୍ତି so there will be no problem ଓକାଲତନାମା is available ସେ fill up କରି ଦେଇଦେବେ ଆଉ so we are passing it over just keep acha put up this matter
ଆପଣ କହିଲେ
put up this matter tomorrow
ଫୋନ ରେ କହିଦେବେ
next
Item 5.
Here, the appellant was in custody since 9/9/2014. Thereafter, this honorable court granted bail on 6/2/2023, interim bail. Thereafter, he is now in custody for 1.5 years now. 6/2/2023,
interim bail for what period
3 months.
3 months okay
Your Lordship, thereafter, I have also filed the surrender certificate. And now,
an IA has been filed for interim bail.
yes,
12
now
that
he is more than 1 year in custody.
no, more than 1 year mane after that
Your
but
Lordship,
what is the total period
total it will be 11 years, more than 11 years. Your Lordship,
okay you obtain that custody certificate and you have got that IP which
IA copied out
I have the surrender certificate.
please serve a copy of the interim application lekhandu IA number 1209 of 2025 which is an application for interim bail filed by the appellant Nagesh Naik. The learned counsel for the appellant submits that the petitioner was granted interim bail for a period of 3 months in this case number 688 of 2017 as per order dated 6/2/2023 and after availing the same he surrendered at right time. The learned counsel for the state submits that he has not received the copy of the interim application. Let a copy of the interim application be served on the learned counsel for the state by tomorrow. Kali bhitar dei diyontu. The learned counsel for the state shall produce the custody certificate and also obtain instruction regarding the conduct of the petitioner while on interim bail as per the aforesaid order dated 6/2/2023. Put up this matter on such and such day.
Parking as a right in the custody.
Yes, next.
Lordship is fixing it to them.
You will come after some other.
Item 6.
Last one, Lordship. 6. Last one call for the
Yes, sir. That is the conduct of the petition.
You are granted interim bail for a period of 3 months. That is the order dated 15/5/24. And how you conducted yourself? We ascertain that company closely related. Sola and Vinay, there is a feeling still prevailing between the two. Though he is not being reported in the locality, possibility of unfolding cannot be ruled out. The petitioner is not a habitual under or an incident. Which he not ruled out. The IA number 179 of 2025. This is an application for bail, the interim bail. As per the order dated 8/4/2025, the London Council for the state has produced a written instruction received from IIC Rajnagar Police Station to the effect that the petitioner is not a habitual offender and no incident against him has been reported during the period of interim bail. The written instruction is taken on record. Considering the period of detention of the petitioner in judicial custody, and since the petitioner has not flouted the terms and conditions of the earlier interim bail order dated 15/5/24 passed in IA number 548 of 2019, keeping in view the ratio laid down in the case of Letty versus so-and-so, we are inclined to grant the interim bail for a period of 3 months to the petitioner. IA is disposed of, fix a date, will produce the surrender certificate. Yes. Okay.
Item 7.
Please. An IA for interim bail on the ground of solemnization of marriage of the only son of the appellant, my lords.
Which is that application?
Where is that? Interim application number 1261 of 25.
When the marriage is going to be solemnized?
On 8th of this.
Yes, marriage card ଦେଇଛନ୍ତି ବୁଝିଲେନି ଆପଣଙ୍କୁ ଆଗରୁ ଏଟା କଣ ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସିଛି?
First of May.
ଫାର୍ଷ୍ଟ ଅଫ୍ ମେ କେମିତି କଣ କରିବ? ଆପଣଙ୍କୁ ବାହାଘର ସେଟଲ ହେଇଥିବ, ଏଇ କାର୍ଡ କେବେଠୁ ଛପା ହବନି, ଆସିକିନି ଲାଷ୍ଟ ମୋମେଣ୍ଟରେ ଇଏ କରିବେ। You verify if it is possible. କୋଉ ଥାନାରୁ ଆସିବ? Take instruction, we are taking up tomorrow. Is this matter tomorrow? IA number 8 is an application for the number say IA 1261 of 25 is an application for interim bail on the ground of marriage of the son of the petitioner, which is scheduled to be held on 8th of May 2025. And counsel for the state sit time to obtain instruction. Look is not tomorrow. Yes, next.
Item 8.
This is IA 1257 of 2025 is filed for interim bail for solemnization of the second daughter marriage on 7/5/2025.
कौन करेगा? अनिचन इंस्ट्रक्शन कार्ड के जो उठने से छपी हो रखो थाना रखो
এটা স্যার ঝিওর থানাটা হচ্ছে মার্সাগাই।
ঝিওর থানা নয় মা, আপন ঘর কোটা?
আপিলেন্টর থানাটা হচ্ছে মার্সাগাই।
মার্সাগাই?
ନାଇଁ ୟେସ୍
ସେଇ ଟାଇପର ଦେଖି ଦିଅନ୍ତୁ ଖାଲି।
ପୁଅର ବାହାଘରଟା ଯୋଉଟା ହଉଛି କିଶୋର।
ନାଇଁ ସେ ନୁହଁ, ଆପଣଙ୍କ ଝିଅ ବାହାଘର ହଉଛି ପରା, ସେତିକି ତ ଆଣିବେ ଆଉ କଣ। କାଲି ରଖନ୍ତୁ ତୁମର 6/5/25 ୟେସ୍ ସିଏ ଲେଖିବି ଝିଅ ବାହାଘର ପାଇଁ ସେକେଣ୍ଡ ଡଟର ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦେଖିଦେବେ। ୟେସ୍ ନେକ୍ସଟ। ଏଇଟା ଫାଷ୍ଟ ଆପ୍ଲିକେସନ ତ CRLA 625 ସେଇଥିରେ ଏଇଟା ଖାଲି ଫର୍ମାଲି ଆସିବ, ଏଇ ଯୋଉ 626 of 2020 ଟା। Yes, next.
May I please? On the filing application for the bail mandate, the appellant is a husband matter, convicted the appellant on section 48302A of Indian Penal Code matter. Judgment dated 4/12/2019 matter.
बाबू रिजेक्ट ହେଇଛି?
No, my lord. In the custody certificate already produced, my lord, in a state,
How many years you are in custody?
10 years. 4/12, 2000.
That is the custody certificate dated হচ্ছে 16/12/24. 16/12 ମାନେ ଆଉ 4 ମାସ ହେଇଗଲାଣି ମାନେ ଆପଣ 11 ବର୍ଷ ହେଇଗଲାଣି। 1 2 3 4 11 years sir.
Judgment, huh?
Judgment.
What are the materials against you?
Convicted the appellant when relying on extrajudicial confession of the accused, my lord, the Dr. PW5, my lord, Dr. my lord, the one eyewitness is PW10, my lord, the sister in the law, my lord, then turned out style, my lord. Let's check. PW10.
Just a minute, you 10 custody ये evidence होची PW10
one eyewitnesses.
Eyewitness not supported the prosecution case.
Sister in the law.
ठीक अच्छी चीज है। तापरे बाकी रहेला कौन?
Doctoral PW5, my lord.
PW5 बोला PM doctor. What is the cause of death?
Cause of death for the homicide in murder.
ये देखिए ये तो आपको
PW5
कोड रखो।
So many injuries are there.
Yes.
So many injury, 8 injuries.
Vigorous merit present, all our 4 limbs absence in a leg. Decomposition is not yet started. Multiple
Cause of death is due to extensive tissue injuries and shock.
Yes.
The injuries found on the deceased are sufficient to cause death in ordinary course of nature. So,
postmortem report is 6, my lord. The accused had no intention of the cause of the death of the deceased, my lord, as the injury found in the body of the
ଯେତିକି injury ହେଇଛି ତାକୁ ଯଦି କାଉଣ୍ଟ କରାଯାଏ କୋଉ ଭଳି ଭାବରେ ମାରିଛନ୍ତି ଜଣା ପଡୁଛି ତ
head injury
ମାନେ ଆଉ କୋଉ ବଡିଟାର ପାର୍ଟ ଛାଡି ନା
appellant could have asserted this na head ରେ କିଛି ନାହିଁ, my lord, କିନ୍ତୁ ଖାଲି body ରେ ଅଛି।
right leg, hands, right thigh, right side of thigh, so on so chest, abdomen, so on so. Multiple refracture is refracture present. All the internal organs, both the chamber, cause of death, extensive tissue injury. अच्छा ये तो गला homicidal death ही गला बाकी आउ कौन रहला अपन नारे
8-9 years above the marriage, love marriage. Love marriage ପରେ ବିଷଣ ତାଙ୍କ ଭିତରେ ଝଗଡ଼ା
issue out of wedlock.
issue of କିଛି ନାହିଁ, this is a cruel ମାନେ ମଦ ଡ୍ରିଙ୍କ କରିକି ମଦ
ଆପଣ କୁହନ୍ତୁ କଣ ମ୍ୟାଟେରିଆଲ ଅଛି?
material
PW10 has not supported.
PW10, my lord.
He has not supported the, you said. What are other materials?
Judicial the brother of the PW1.
PW1.
Yes, sir. PW1, 15 and 17 is the corroborated.
PW1,
15 and 17, my lord.
PW 15 and 7. Let us see the evidence.
Yes, my lord.
It was a love marriage, no ceremony of your. My daughter went to. Acha, he is the father of the deceased. Deceased was my sister. So also the wife of this one. My daughter कौन पूछे? My daughter went.
15 ହେଲା ଭାଉଜ, 1 ହେଲା
one କଥା କହୁଛି. One ଟା କହୁଛି.
1 ହେଲା brother of the deceased. ଭାଇ. F the lodge.
ये भाई एक नंबर साखी भाई.
Yes, ma'am.
Come to paragraph number 2. As it was a love marriage, no ceremony was observed, and my daughter went to the house of the accused and stayed there as his wife. It हवा था my sister हवा था ना. Paragraph 2 रे.
नित्यानंद देव में. Yes, ma'am.
मेरा भूल है. During her stay in the house of this one, the frequent quarrel. अच्छा, extrajudicial confession टा कोडी कहला.
Schedule 15.
one day put it.
The marriage
Notice
Devaki
bleeding injury and this
Vodeshwara.
one so on. By that time, nobody was present. After half an hour of her arrival, accused Bholeshwar ki hai?
Representative.
Acha. Accused Bholeshwar arrived near the body and confessed before me. As Devaki did not listen to him, he assaulted him by means of bamboo plant. And during such assault, Devaki died. So I went to Kurunkote police station law. FIR रे तो किसी नहीं extra judicial confession.
No.
तो नहीं. ये पूरा सुनी की नहीं गला थाना को. अच्छे तो आगे लिखी था ना थाना रे. जे चला रे जे मते ये दोष मानिला कहला मु पिटी किनी मार देइछि. किसी नहीं मु तांगे संग घर जाई देखिली. से मरी पड़छि आगुर मध्य ताको स्वामी स्त्री को भीतर बहुत थर पाटीतुंड झगड़ा हुए. मु ग्राम लोक को पचारियार बुझियारू से माने कहले ताकू सकाळ 10टा बेले सोमवार मार देइछि. बस ग्राम लोक सवारी दी एक्स्ट्रा जुडिशियल कन्फेशन.
Schedule 15. The informant
disclosed
husband
that
Schedule 15. The informant is my husband. The deceased Devaki is my sister-in-law, Nananda. The offense took place 4 years back. The deceased died in her marital house.
No, you see, this PW1 informant, this lady is the wife of that informant. So they all went together. And thereafter, they stated that extrajudicial confession was made. Then the informant goes to the police station to report. And in the police station, in the FIR, there is no material that any extrajudicial confession was made by the accused. So, and semane villagers to janile je ye taku mar dechi. So, this is a subsequent development, it can be said. Though FIR is not an encyclopedia, but when you are excluding this important part, it creates doubt that whether the accused actually confessed his guilt before the in-laws family members like PW1 and PW15 and PW16. Who is PW16?
17.
PW 17, sorry. 17 ki hai?
Son.
Informant is my son. Nityananda, deceased is my daughter. Deceased is my daughter, Prabhuji. ये ताले
informant होची भाई. Schedule 15 होची ता भाऊ.
informant होची भाई. ଆଉ
PW15
ये होची ମା ବୋଧେ ଏ ଯୋଉ PW17 ଟା ନଳିନୀ ଦେବୀ ଆଉ PW15 ଟା
होची ता भाऊजो.
PW15 ଟା ହଉଛି ତାର ଭାଉଜ ମିନତି ଦେବୀ. These are the three witnesses to the extrajudicial confession. ଆଉ କଣ ଅଛି?
And the 18 injuries there, so intention is there.
Is in custody kete dele ଆଉ ଏଟା part
10/4/2006.
No, ये custody certificate ଟା ଅଛି ପୁରା. The land and counsel for the petitioner, land counsel for the state. The land and counsel for the petitioner submits that the custody certificate which was produced by the state from Superintendent Circle Jail on board dated 16/12/2024 would indicate that as on that date, the petitioner was in jail custody for 10 years, 7 months and 4 days, and thus by now he has already remained in custody for more than 11 years. Stop. If for that PW10 is an eyewitness to the occurrence, but he or she, PW 10 की है?
C, my lord.
But she has not supported the prosecution case for which she was declared hostile. Stop. The witnesses to the extrajudicial confession of the petitioner are PW 1, the informant, PW 15, the sister-in-law of the deceased, and PW 17, the mother of the deceased. The Learned Counsel submits that though all these three witnesses have stated that the petitioner confessed his guilt before them to have assaulted the deceased by means of a bamboo plank, and thereafter PW1 went to the police station and lodged the first information report, but the extrajudicial confession part is conspicuously absent in the first information report, which creates doubt about such a version by the three witnesses, and therefore the petitioner has got good chances of success in the appeal, and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Learned Counsel for the state, apart from placing the statement of aforesaid three witnesses to the extrajudicial confession, place the evidence of the doctor bracketed PW5 who conducted post-mortem examination and noticed multiple injuries on different parts of the body, bracket excluding head, and opined the cause of death was on account of extensive tissue injury and shock. Considering the submission made by the Learned Counsel for the respective party, nature of evidence adduced, absence of any direct evidence, the period of detention of the petitioner in judicial custody, and also absence of chance of early hearing, we are inclined to release the petitioner on bail. Yes.
Item 10.
Yes, item
Last
10.
question, Lordship directed to take instructions with my lord regarding status of the victim.
You are in that ashram school, what you are?
Watching as a hoop, my lord.
And what was the age of the victim at the point of time? No, Dr. Mangal, 14 to 16, not below 14, not above 16. And due to this, she gave birth to a baby, and now the baby has been left in that specialized adoption agency. 10-month food, she is now there. How many years you are in custody? 7 years, 10 months now. Date of custody. Have you obtained that custody certificate? No, get it. The Learning Council for the state has produced the status report of the victim, which is taken on record. He seeks some further time to produce the custody certificate. Custody certificate of the petitioner. So also to take instruction regarding criminal antecedent, if any, against the petitioner, put up this matter after summer vacation.
Item 11.
Last occasion, you wrote to private case for instruction number.
Report has gone.
This one, so if you can see continuing medications and blah, blah, blah. ରହିଲାଣି
ମୁଁ ଦେଖୁଥିଲି ଏଇଟା ମୁଁ କାଲି ରିସିଭ୍ କରିଛି ଗୁରୁବାର ଦିନ।
wait the period of detention ହଉଛି 17/10/2017 ଲେଖା ହେଇଛି ସେକେଣ୍ଡ ପେଜ ରେ। ଜଜମେଣ୍ଟ ପାଇନାହାନ୍ତି ଆପଣ?
ନାଇଁ ପାଇଛି ମୁଁ ପେପର ବୁକ୍ ଟା ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର ରେ ଯାଇଥିଲା 3 ମାସ। ହଁ ଆଗରୁ ଗୋଟେ ଅର୍ଡର ହେଇଥିଲା
23/3/2023 ପର୍ଯ୍ୟନ୍ତ କଷ୍ଟଡିରେ ଥିଲା ବୋଲି ଟ୍ରାଏଲ କୋର୍ଟ ଲେଖୁଛନ୍ତି, ତାପରେ ବାକି ଯାହା ଯାଇଥିବ ହାଇକୋର୍ଟ କୁ ଯାଇଥିବ।
ଆଜ୍ଞା ହାଇକୋର୍ଟ କୁ ଯାଇଛି 3 ମାସ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ ରେ ଯାଇଛି।
ମାସ ନାହିଁ, ସିଏ 4 ତାରିଖରେ ଅର୍ଡର ହେଇଛି 4/7/24 ରେ ବେଲ୍ ଦିଆଯାଇଛି 11 ନଭେମ୍ବର, ମାନେ ପାଖାପାଖି 4 ମାସ ଦିଆଯାଇଛି, 4 ମାସରୁ ବେଶୀ ଦିଆଯାଇଛି। It's not 3 months.
ବର୍ଷ କେତେ ମାସ during trial? ବର୍ଷ କେତେ ମାସ during trial? 17/10/17 20/3/23
ନାଇଁ ସିଏ ତ ଅଛି, ସେଟା ତ ଜଣା ପଡୁଛି କଷ୍ଟଡିରେ ଥିଲା ବୋଲି। ସେ ପିରିୟଡ ଟା ଲାଷ୍ଟ କଲମ ରେ ମେନସନ ହେଇଛି page 2 ରେ, page 2 of the judgment last column period of detention। ତାପରେ ହାଇକୋର୍ଟ ରେ ଅପିଲ କଲା ପରେ ଏଇ ଯୋଉ 4 ମାସ ବେଲ୍ ଯାଇଛି। So nothing adverse is reported.
This is the report now.
71 years, huh?
Your report says it is 71 years. 71 years, your report says it.
As
per the voter ID card, 71.
As per warrant 66 years.
No, warrant.
Special geriatric care.
এটা কোন allegation কোন 302 আই উইটনেস অଛନ୍ତି?
ଆଇ ୱିଟନେସ୍ ତାର ସନ୍ ଇନ୍ ଲ ଯିଏ ଯାହା ଡଟର କୁ ମାରିଛି, ସନ୍ ଇନ୍ ଲ PW18 ହେଲା।
ସିଙ୍ଗଲ ମର୍ଡର?
ଆଜ୍ଞା
Are the land counsel for the petitioner land counsel for the state? The land state has produced written instruction received from senior superintendent circle jail on board, which indicate that the petitioner asked for the voter ID card is aged about 71 years and is suffering from different ailments and treated in jail hospital on board. The report is taken on record. It appears that the petitioner was in jail custody. From the trial court judgment, it appears that the petitioner was in jail custody from 17/10/2017 to 23/2023. And after his conviction, he preferred this appeal and he was granted bail as for the order dated 4/7/2024 in IN number 1804 of 2023 till 11th November 2024. The land counsel for the petitioner submits that in view of the NALSA guidelines and the special campaign on old prisoners and terminally ill prisoners, the bail application may be favorably considered. Land counsel for the state has not disputed about the age of the petitioner, considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody, the age of the petitioner, and keeping in view the NALSA special campaign on old prisoners and terminally ill prisoners, we are inclined to release the petitioner on without parole. Communicate the order to the concerned trial court. We in turn shall communicate the same to the so and so.
Item 12, my lord, clerk of bail, IN number
देखिए Sashmita Nandal and Namai case. Yes, Ms. Tripathi, कौन कहलो?
My lord, clerk of bail, IN number 225/2023, offense committed under section 302 of IPC.
No, you have the prisoner's petition has been received in your name. Have you filed wakalatnama?
My lord.
Okay. Now, peruse the prisoner's petition in which at flag C, which is dated 23/4/2025, in which request has been made for engagement of Vinafani Tripathi and Nandini Tripathi to be the counsel in place of Ms. Vijayalakshmi Tripathi. The FRAIR is accepted. Wakalatnama has already been filed in the case. Yes, what is your case?
My lord, only 302 of IPC, date of occurrence 15/7/2021. My lord, prosecution case is brief as it is derived from the FIR. Is that the informant guided us and appeared in the Golara police station and lodged a report alleging therein that is the 15/7/2021. During the daytime, her husband Dilidas and one of the Negawas, Bhagadas, alias Binod Das had been to their labor work where someone has stolen and the money of Bhagadas. But in the evening,
Don't read it out. We are asking some questions, you put it. Don't read it. You are arguing a bail application. What is the name?
Dilli Das.
Huh?
Dilli Das.
Dilli Das. What is the date of occurrence?
15/07/2020.
15th July 2021. So eyewitnesses are there or not?
No. Someone is
eyewitness.
evident.
Just one. So if it is a case based on circumstantial evidence, what are the circumstances against you? Whether it has been discussed anywhere in the judgment that these are the circumstances on record against you in the trial court judgment.
Intention ta para 13 ରହୁଛି.
Para 13.
Intention.
No. Judgment ରେ କୋଉ discussion ହେଇଛି ଯେ 1, 2, 3, 4 ଏଇଗୁଡାକ ହଉଛି circumstance. Is it correct that is a case of not a case of direct evidence?
No direct. Circumstance में para 11 दी जाती है.
Paragraph 11 कि कोई पेज कौन?
Page 17 internal page, current page और running page 9.
BW 4 and 5 stated that they heard loud sound on the rooftop where the deceased was slept. Immediately they rushed to the spot and on the staircase they saw the accused was coming down. Through this staircase hurriedly.
Right.
Then they found the deceased with profuse bleeding, having rupture injury on the front floor. They also noticed one cement stone stained with blood was lying near the dead body.
Not found in your book.
The doctor found 9 number of antemortem injuries.
No. Para 8 that are discussed in the judgment.
The reporter was like human blood detected in exhibit A, B, C, D, G, G1. Adhiru, ଏଇଟା ହଉଛି cement stone, ଏଇଟା ହଉଛି full shirt, wearing apparels of the deceased. Deceased. ଆଚ୍ଛା G1 ମଧ୍ୟ ହଉଛି accused ର, ସେଥିରେ ମଧ୍ୟ human blood ଆସିଲା.
PW1 hostile Vijetas.
Total custody period?
More than 4 years.
More than?
More than 4 years. 4 years.
Limited. वो साथ एक खुश रहा. सो साथ एक खुश रहा अपन.
Why he committed, according to the, what is the motive behind commission of the crime?
PW1 and 3.
The intention only mentioned as described in para 13. From the upper petition, I find the accused has got an intention.
Trial court of Consolidated. One to hostile legal.
PW3.
No intention. Both are labor or degree.
Position is the church of the letter.
देखी ना
ये कौन करे? Accused?
Labor.
Minor both on labor. ନେଗୋବର ମାନେ ଇନ୍ଦିରା ଆବାସ ଘର ପାଖାପାଖି ବୋଥ stair case same stair case no doctor evidence
Just before occurrence, there was a abusing by the appellant to the informed.
ହଁ ସେଟା PW3 କରି
PW3
400 ଟଙ୍କା କଣ ନେଇଯାଇଥିଲା ତାକୁ ବୋଧେ କଣ ଦିଲ୍ଲୀ ଦାସ ମୋର 400 ଟଙ୍କା ଚୋରି କରି ନେଇଛି ସେ ଆଜି ଯେଉଁଠି ଶୋଇଥିବ ତାକୁ ପଥର ଛେଚି ମାରିଦେବି
ଏ ପଥର ବି ଛେଚି ମାରିଦେଇଛି।
stone weight ହଉଛି 40 kg 40 kg ଜଣେ ଉଠେଇ ପାରିବ ମୋଟା ଛେଚିବା କେମିତି
ଏ ଷ୍ଟେଟମେଣ୍ଟ ଟା କଣ ପୋଲିସ ପାଖରେ କି 164 ରେ କହି ନଥିଲା PW3 ଏଟା ଆଇଓ କିଏ
PW7
ଆଇଓ କାଇଁ PW7 ଆଇଓ PW8
PW8 ନା
PW8 ଟା ଡକ୍ଟର PW7 ଆଇ
88 PW8 ଟା IAS
PW8 ଟା ଆଇ ହଁ ସରି PW7 ଡକ୍ଟର
नहीं सेटा तो कन्फर्म प्रूव ହେଇନି ଆଦେରେ PW3 କୁ ଯୋଡ଼ାକ ପଚାରିଲେ ଏזה ତ କିଛି ନାହିଁ ଖାଲି ପଚାରି ଦେଇଛନ୍ତି it should be proved to the investigating officer also अच्छा 164 କଣ କାର ହେଇଥିଲା କି
ହଁ 164 ହେଇଛି
164 PW3 ର ହେଇଥିଲା
ଆଜ୍ଞା ଆଜ୍ଞା
କାଇଁ ତା ଷ୍ଟେଟମେଣ୍ଟ ଟା କାଇଁ
କ୍ରସ୍ ଏକ୍ସାମିନେସନ
नहीं क्रॉस एग्जामिनेशन तो है पचरा है परिदा ढांचा ये ना कौन PW3 रो
राजेंद्र
राजा दास
अच्छा को विलेज
मधु सोनसो गरी पाखर रहउथला दिल्ली दास सब कुछ से मारी देवी तो कहिछि हो तो पचार देले केमती सब से आकर देश सब आदबो
इवनिंग टाइम रे कहिछि कि राति रे 11 AM रे जतबेले
you are found
देखिना
you are found coming from that staircase while the other two were going up after hearing that sound and they found that in the top of the roof the dead body was lying and there was profuse bleeding injury and a stone was lying and so it hଉଛି ଗୋଟେ circumstance ଆପଣଙ୍କ against
तो देवाटा ना सर
ରହିଛନ୍ତି ଜଜମେଣ୍ଟ ଟା କେତେ ଆଉଥରେ ବାହାର କର ତାର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଟା ଆଣନ୍ତୁ ଆଉ ଇଏଟା ଆଣନ୍ତୁ ଯୋଉ criminal antecedent
ଆଜ୍ଞା
IA number so and so this is an application for bail अच्छा ସେ ଯୋଉଟା ମାଗୁର ଡାକିଥିଲି ସେଟା ଅଛି ନା সেটা জেনারেলি JCRL এ রেখে এইটা লিখে দেবে for bail and counsel for the state takes some time to produce the custody certificate so also to obtain instruction regarding the criminal antecedent if any against the case of this matter after summer vacation. Yes.
Item 13.
The present appellant is inside custody since 9/11/2019, my lord, and I have filed one IA for interim bail on the ground of father's illness, my lord. The present appellant has been convicted under section 376 AB for
376 everyone notice जाइए
notice
sufficient जाइए so on ground नहीं जंदी
on the ground of father's illness, father is suffering from cardiac problem, my lord.
Where have you stated in which paragraph?
Para, my lord.
2.
My lord.
Any medical document you have given?
Yes, my lord. I have annexed it.
ଏଗୁଡାକ ସିଧା କରିବ ବୁଝିଲ ମେଡିକାଲ ଡକ୍ୟୁମେଣ୍ଟ କୋଉଠିକାର ଆଚ୍ଛା ଆଚ୍ଛା ଏସଏଲଏନ କୋରାପୁଟର ଶହୀଦ ଲକ୍ଷ୍ମଣ ନାୟକ ମେଡିକାଲ କଲେଜ କେବେକାର ଏଟା ରିପୋର୍ଟଟା ହଁ ଏବେକାର ଭିଜିଟ ଫୋନ୍ ହଉଛି 3rd April 2025 ये नंबर 1131 तो 11 এটা গোটে কোন ভুল নম্বরটা দিয়েছি এটা ঠিক করিব দেখছো তো এটা 11631 এই যেটা 1131 হবে যা কুয়া হচ্ছে লেখিকিনি নিও মুন্ডটাও টুঙ্গা দিবেন হ্যাঁ 1131 of 2025 is an application for interim bail on the ground of ailment of the father of the petitioner who is stated to be suffering from cardiac problem. Medical documents in support of the averments taken in the interim application has been annexed to the same. The learned counsel for the petitioner served a copy of the interim application on the learned counsel for the state in court today, who seeks some time to obtain instruction. Kodi ghara kodi gara?
It's CORAM.
Next week ରଖୁଛି ଦେଖନ୍ତୁ ଆଣନ୍ତୁ ଯଦି ହେଇପାରିବ ହେଲା put up this matter on 14th 15th percent on 15th of May 2025.
Item 14.
Item 14 may please next. The case convicted under section 302 and other offences, my lords. And the appellant is in custody since, my lords, 28/6/2021, my lords. Until date, I'm inside, well, 21/6/2021. Until date,
Have you served a copy of your bail application? Deposition is also available with you?
It is on record, my lords.
Deposition copy available.
Available.
I have annexed it, my
Bail
lords.
application.
Bail application ଦେଇନା
Bail application IR ଅଛି.
ସେଇ ଆଇଏ ଟା କହୁଛି ଆଇଏ କପି ଦେଇନାହାନ୍ତି ସେ କହୁଛନ୍ତି ନା ମୁଁ ସେଇଥିପାଇଁ ପଚାରୁଛି this application IA number 2579
And PW 27 and 9 to 11.
ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି ନା ଏଟା ଫାର୍ଷ୍ଟ ବେଲ୍
First time.
डायरेक्ट एविडेंस ना सर्कमस्टेंशियल
My lords, PW 18 was the direct evidence.
PW
18.
criminal eyewitness
Injured as well as eyewitness.
injured as well and who is the doctor
My lord, PW 15.
15
Ponder.
देखिए PW 18 that is also 30
My lord, injured as well as wife of the present appellant, my lords.
मालती विश्वाल
My lord.
कालिया विश्वाल deceased
No, my lords, Kalia Biswal is the appellant here, my lords, as well as the husband of Malati Biswal.
oh that means your wife has deposed against you
My lord's wife is the injured along with the deceased. They were sleeping, my lord, in a place. And finding that, my lords,
the deceased expired prior 2 years once so I and Sanatan Das deceased were sleeping in front of one servant. Kalia and Raju Giri stabbed us by means of small sword. They stabbed to my abdomen and then stabbing my husband on the chest. Kalia stabbed in my abdomen, which was back for an hour. But Raju Giri controlled of me. At that time, I saw Kalia, which was repeatedly stabbed. The swords also to his skin and circumstantial. And PW 15. তিনটা পট হচ্ছে and cause of death was shock and hemorrhage.
Direct corroboration.
My lord, corroboration so far as one injury is concerned, my lord.
One injury.
My lord's external injury number 2. That says only one.
How many years you are in custody?
My lord, since 21/6/2021, my lords.
तो 4 वर्ष भी ହେଇନି छुट्टी पर रहता put up this matter after summer vacation, ensuing summer vacation. Land Council for the state shall produce the custody certificate and also obtain instruction about the criminal antecedent. Yes, next.
Item 15.
Yes, Mr. Mishra.
Please, matter. So there are two appellants and two appeals. They have been convicted under section 302 and others, like in prison. The lordship on the last of, and they are in custody for more than.
Mr. Tripathi is.
My lord, I am present.
They are in custody for more than 9 years. The lordship called for the antecedents. Here I humbly submit the IAC plant site.
This somebody has 9 criminal antecedents.
Those are all.
CRL 1198.
Yes, no.
Yes, sir.
There are, that is Sagir.
तो छोड़ो तापर एटारो जो 1197 1197 ना अच्छी किसी criminal antecedent 9
Sagir दार किसी नहीं साइड में आ रहे नोट antecedent
ये कौन है eyewitness ना
eyewitness is there 10 and 14.
Just a minute.
10 and 14.
Madam, before I proceed, my lord, the antecedents supplied by the plant site in charge.
आपको छाड़ से जो antecedent हो छाड़ दियो
नहीं छोड़ा कितना नहीं है यार
से परे देखियो
नहीं सागलो देखियो
हां से एटा कि कोन तो आपण ए जोटा यार antecedent नहीं किए सा नाटा कोन
Sagir
119 Sagir माने जो 1197 वाला
my lord
अच्छा CRL 1197/2024 MD Sagir तार period of detention
not more than 9 years. January and August. 9 years 3 months.
अच्छा डेट ऑफ अरेस्ट लिखाई 17/1/2016
आगे
16 ले 9 years हो गया
आगे
more than 9 years होता है अच्छा who are the eyewitnesses you said
10 and 14
PW10 PW14 और डॉक्टर की है
डॉक्टर 15
PW15
Well, last time also I submitted that so far the postmortem is concerned.
आगे eyewitness question तो PW10 कौन पूछी
आगे
आपकी कॉन्फाइन कौन थी जो सागिर कौन थी तार नाम जी जिगजैग
सागिर alias जिग आगे
detained us on the road while we are proceeding on the heavy lane road. Sahid put a revolver connecting to the body of my uncle near his ear. First I ran away from the spot out of him. My brother also started running, following me. I found at the ring road one red colored Maruti Jain has been parked where Raja was sitting in the car. I heard sound of gunshot and I turned back and saw my maternal uncle fell down on the ground. Myself and my brother ran away
towards traffic gate.
Sahi zigzag swan so.
Chase just towards the traffic gate.
कहा तेरे
Sahi
जाते हैं.
Zigzag has not.
Zigzag press नहीं कोडी ये ता धइला देखो आई विल शो इट
ठीक है रूंगा
ये धइला से माइला
ठीक है PW10 रो एविडेंस वाज सी
आगे
Sahid was with bomb and deceased died out of gunshot injury.
Yes.
PW15 रो ଇଏଟା କଣ ଏଭିଡେନ୍ସ ଟା କଣ cause of death କଣ one entrance wound was present and the entrance wound surrounded by so and so bullet entrance wound was merged. The entrance wound revealed that from the skin exit wound भी अच्छी गोली पसी बाहर जाइए से बोल को second antemortem bullet was found close to some bullet was extracted from the left से आउ गोटे neck रे रही छी bullet was extracted ता माने bullet रो जोटा सेटा भितरु बाहरला आ बाकी जोटा थिला सेटा बाहर किनु पड़ै छी so right so the position of the bull I cannot say not mentioned cause of death was due to antemortem firearm injury
14 also is not said anything.
Firearm injury. What about 14 number Sakhi? Sagir, zigzag standing, my brother was holding a pistol, got hold of my hand. I tried to rescue my according to escape in Maruti car's mansion. Both and after shooting my uncle.
The accused person detained the accused child, took out a gun and aimed at my uncle on his ear. Accused Sagir zigzag was also standing with him. My brother got down.
Standing there.
Yeah.
No overtake is
Yes, Mr. Tripathi. Confine to ya upare zigzag upare.
Zigzag upare gochi. Paragraph 15. The informants. He also admitted during his cross-examination by the learned additional PP 154 Evidence Act, when the accused pointed a pistol on his mama, he heard a gunshot and turned back and found that his uncle had fallen down. And that the accused
PW
14. Yes, informant. And Sagir was found.
PW 14 evidence को आसुनांदी PW 14 पर हमें धरिचु. Paragraph number 2 को evidence copy देखो.
My paragraph 8.
कौन है जजमेंट रू पढ़ुछन ना PW 14 रू पढ़ुछन
जजमेंट रू
अच्छा बेटी PW 14 एविडेंस
आसंतु
जज आपण एविडेंस एविडेंस क्लियरली कहूची द अक्यूज्ड मोहम्मद साइद देखो पैराग्राफ 2 टा देखो
यस
PW 14 देखछंदी PW 14 नाउ छी मोहम्मद वासिम राजा
यस
पाइले तापर पैराग्राफ 2 को आसंतु Incident took place about 6 years back. On a particular date, so I was returning so and so on the way near Santala Chowk Hump. Accused persons detained us. Accused Muhammad Said took out a gun and aimed at my uncle. Uncle Dauji deceased.
Yes.
On his ear. And accused Muhammad Sagir alias Zigzag was also standing with him.
Yes. My lord, may kindly come to paragraph 6.
Paragraph
6, next page.
6, achha.
Yes, it is a fact that I have stated before the police that after proceeded
you were declared hostile.
Distance,
yeah.
When the accused pointed a pistol on my mama, I had a gunshot and turned back and found that my uncle had fallen down. The accused Sagir.
This he has stated before.
Sagir was found pressing my uncle with his hand.
Mr. Tripathi, this he has stated before police. He admits that I have stated before police. But what he is now stating in court, that is the substantive piece of evidence. It is not that 161. Vartaman court re kohuchi je mu dekhili mane ye banduk dharthila ye fire kala ye ta pakhre chhida aithala. माने ये जो accused पाई जहार नारे criminal antecedent नहीं सब छिड़ा इतला that the difference between the two is that against one there are 9 criminal antecedent and he is the man who was having gone and he is the man who has caused the injury and that is the also the result of death या हत्तेरे कोनोसी बंधुक थिबा कथा मध्य ए दीटा आई विटनेस के कहूना ହେଲା ତେଣୁ ପୋଲିସ ପାଖରେ PW14 you are right he has stated that ମୁଁ ଦେଖିଛି ଇଏ ତା ବେକକୁ ଧରିଥିଲା ଆଉ ଇଏ ସେଇ ଯୋଉ ଘଟଣା ବେଳେ
ନା paragraph 9 ରେ ବି ସେ କହିଛି sir it is not a fact that I had not stated before the police that the accused Mohammed Sagir was found pressing my uncle with his hands while Shahid was holding a pistol in his hand.
ସେଇଟା ସିଏ କହୁଛି ଯେ ଏଇଟା ନୁହେଁ ମାନେ ଡିଫେନ୍ସ ସଜେସନ ଦଉଛି ଯେ ତମେ ଏମିତି ପୋଲିସ ପାଖରେ କହିନ ଯେ ଯେତେବେଳେ ଏଇ ସାଗିର ତା ନେକ୍ କୁ ପ୍ରେସ୍ କରୁଥିଲା ସେତିକି ବେଳେ ସାହିଦ ଇଏ ଧରିଥିଲା ବୋଲି ଏଇଟା ଆଇଓ କେତେ ନମ୍ବର ସାକ୍ଷୀ କୁହନ୍ତୁ ଆଇଓ PW କେତେ with investigating officer PW 25
second number. 24-25.
You come to paragraph number 34 of IO's evidence. এটা ডিফেন্স কনফ্রন্ট করিকিনি সেটি সজেশন দেলে এটি এটা প্রমাণ হইছে পেজ নম্বর 30 প্যারাগ্রাফ 34 PW 25 পড়ন্তু পড়ন্তু পড়ন্তু
The fact that PW has not stated that Mohammed Sagir was just found pressing my uncle with his hand while the accused Mohammed Said was holding a pistol.
ହେଲା ତ ଏଇ ଯୋଉ ଲାଇନଟା ସେ କହୁଛି ଯେ ଏଇ କୋଡା ଲାଇନ ଆମ ପାଖରେ କହି ନାହାନ୍ତି ହେଲା ତେଣୁ ଯୋଉ ଇଏ ପ୍ରେସ୍ କଲା ବେଳେ ସିଏ ହୋଲ୍ଡିଂ କରିଥିଲା ସେଟାକୁ କହି ନାହାନ୍ତି ଲେଖନ୍ତୁ ହାର୍ଡ ଦି ଏଇଟାକୁ ଲେଖି ଦିଅନ୍ତୁ Mohammed Said of bail application, let it be pressed after summer vacation. That is CRLN number 1198 of 2024. Baki jo 1197 of 2024, MD Sagir alias Jigja, tar lekhuntu IN number 304 of 2025. Are the Land Counsel Mr. Dilip Kumar Mishra, Land Counsel for the petitioner, Land Counsel for the state, and Mr. Tripathi, Land Counsel for the informant. The Land Counsel for the petitioner submits that the petitioner is in judicial custody for more than 9 years. And there is no criminal antecedent against him. As for the eyewitnesses' account of PW10 and PW14, co-accused MD Sahid alias MD Said was holding a gun and fired gunshot at the deceased, which also gets corroboration from the medical evidence adduced by PW15. The Land Counsel submits that only material which is available on record against the petitioner as per the eyewitnesses account is that the petitioner was present in the scene of occurrence when the co-accused Mohammed Said alias Mohammed Said committed the crime in firing gunshot. He further submits that though PW14 stated about tracing of the neck of the deceased by the petitioner, while the co-accused Mohammed Said was holding pistol in his hand, but it has been confronted to PW14 and proved through the investigating officer PW 25 that he has not made any such statement in his statement recorded under section 161 CRPC. Further submits that in view of the available material on record, there are good chances of success so far as the petition of the appeal, so far as the petitioner is concerned. And since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, also the learned counsel for the informant, and both of them placed the evidence of the eyewitnesses PW 10 and PW 14. So also the evidence of the doctor PW 15, who has stated that the cause of death was shock from antemortem firearm injury. Learned counsel for the state has already this instruction that there is no criminal antecedent against the petitioner, considering the submission made by the learned counsel for the respective parties, nature of evidence on record against the petitioner, since the main role has been attributed against the co-accused Muhammad Saeed alias Muhammad Saeed, further taking into account absence of any criminal antecedent, so also period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail subject to condition that while bail, he shall not try to come in contact with the family members of the deceased and shall not indulge in any criminal activities. Violation of any terms and condition shall entail cancellation of bail. Yes.
But so far the other one, Saeed is concerned that I find an affidavit.
After vacation. Next.
No, we kept on the call.
It is likely to say praise in view of the eyewitnesses account of so and so and the medical evidence, we are not inclined the petitioner on bail stands rejected.
Yes, I'm not pressing. I'm saying that the antecedent affidavit may be kept on record.
Yes, after vacation, yes.
Item 16.
It was on video. As in the appellant has been convicted for life. Commission of offences under section 302 and 201 of IPC. Is been in custody since 29/5/2023. Was not enlarged on bail.
Have you received the deposition copy? So what is the allegation against you?
No, the allegation against me is that the deceased is my wife and she was found hanging in the house and there are no eyewitnesses to the said occurrence. And the allegations and the learned trial court relied on the Dr. PW 11.
So, though your case is that she was found hanging, but the doctor has opined that the death was due to asphyxia as a result of compressive force found on the neck and its complications, and the nature of death is homicidal. So, no ligature was found, which you ordinarily expected in case of hanging. Rather, it was found that multiple reddish fingernail abrasion of different shape and sizes are present on both cheeks and nasal base.
That shows the struggle.
So, with just paragraph 4 of the medical opinion of the doctor,
Yeah.
it is showing that all the injuries described above noticed on the dead body are antemortem in nature and is corresponding internal injury subjective of constriction of neck by a soft and broad ligature material.
It is not that it is, if it would have been a case of hanging, it would have been an oblique shaped ligature mark would have been there, right? And that is not there, rather it was found that some soft material has been used and due to some kind of struggle at that point of time, the nail marks were found on the cheeks, nasal bridge, area nail marks. So that is not a case of suicidal death, it's a case of homicidal death. Now the question is, your wife was staying with you and she has made a homicidal death. What is your explanation? How she made to homicidal death?
Along with us, 2 of our children were also residing who were PW 9 and 10. They were the first to find out that the mother was hanging. PW 9 was the son who has first informed the informant about the death of their mother. He has stated in paragraph number 2 of his deposition that in the morning at about 6 a.m. my father went to his mason work, and at about 7 a.m. I along with my sister went to a tuition. At that time my mother was in a house. At 8 a.m. I along with my sister were returned to our house and we found a mother was hanging down from a beam, Dula in our house.
अरे सीए देखला बेलू ये माँ झूली थला बाप तार काम कर देगी पलि जाइए तापरे ये देखिले माँ को झूली किंतु माँ किंतु झूली मरीनी झूली थे मरी से अलग प्रकार आसता लिगेचर मार तेणु ये तार काम कर दे पड़ेला टंगे देकिनी पिला उठिले देखिले माँ झूली कौन असुविधा कौन है?
The father had left for work before the children.
प्लीज नब ना मुझे भारी तेणु मो आबसेंस रे ये झूली कि मरी किंतु सत कथा बाहर डॉक्टर्स एविडेंस रू जेटा गोटे सुइसाइडल हैंगिंग में इट्स ए केस ऑफ होमिसाइडल डेथ. So there is no third person except you, your wife and children. कितने वर्ष रही जमा 1 year रही छुट्टी पर आस आफ्टर समर वैकेशन. Yes, next.
Item 17.
Malad, I'm on behalf of Suryakant Dipedi, can take this after vacation.
After summer vacation, next.
Yes.
Item 18.
For the opposite peddler
नहीं ना लिखिवा दरकार की मोबाइल डेली बेसिस रे काले कोन थीबो इंस्ट्रक्शन
डायरेक्ट टू सर्व मी कॉपी.
ओह कॉपी देना थी कॉपी सर्व आईए नंबर so and so. This is an application for bail. Let a copy of the interim bail application be served on the learned counsel for the informant. Stop. Learned counsel for the appellant seeks for an adjournment till after ensuing summer vacation. Let the deposition copies of all the witnesses be supplied to the land council for this also in the meantime after summer vacation.
Item 18.
Dina the deposition copy. Beyond Highly Mona give another copy of deposition. If you are having or make it Xerox and hand the learned counsel for the IA number so and so learned counsel for the state submit that he is not having the deposition copies with him. Let the learned counsel for the appellant supply the deposition copies to the learned counsel for the state. Put up this matter on circumstantial after summer vacation. Yes, next.
Item 19.
Second after vacation.
Yes. Summer vacation.
Item 20.
Summer vacation.
After summer vacation.
Item 20 minutes, how item? The
item
number Sub item 2 millers.
Which one?
Millers, it is
20.
items number 20 millers. 8th of 2024.
Yeah.
My name is there, but I am not obtained the Vaklatna miller. If the lordship that I'll assist a lot.
No, the prisoner's petition has been received.
Yes, but
And maybe the wakalatnama is here.
my Vaklatna is not there, millers.
No.
Huh? Not there, millers. I am not.
Yeah, no, is there. Blank,
Somebody has said.
Blank, कुछ कितने और पेज लिखे?
black. थोड़ा अच्छी वकालत
तो नहीं वो इतनी अच्छा ठीक है एक वकालतनामा दिया तो उसे फिल अप कर लूँगे to fill up the wakalatnama the the prisoner's petition received from jail for at flag A for engagement of advocate Anand Narayan Patnaik instead of Ikta Agrawal. Mr. Patnaik is present. The wakalatnama which has been sent from jail we filled out by Mr. Patnaik and we filed stop. The name of Ms. Ikta Agrawal shall not be in the cause list henceforth. Yes.
Item 21.
Please wait and fill up that wakalat. Yeah.
The mother of the petition.
See, ये गुड़ा को देवे से जो 50 टंकार अपन को welfare fund ticket टा सेटा को मारी अन्य की दवा दरकार नहीं. But yes.
Last question, the report whether the mother.
Last time तो किसी यही नतला खाली admit call for the trial court report आस्तेला records मंगाइतला और वाइतला deposition copy दवा पाएं दे दी चंदी.
Mention it IF on the date of the
IN number किते
1276.
अच्छा कहाँ रटे थी जी?
Mother only son and it was
किबे डे थी जी? वो 3 ही 5
in pattern. 352,000.
कुड़िया लोको कुड़िया रहा.
Thank you.
IN number 176 of 2025 is an application for interim bail on the ground that the mother of the petitioner has expired on 3/5/2025. In order to perform the obsequious ceremonies, the presence of the petitioner is very much necessary. Land Council for the state has produced the report from the inspector in charge, Tangi Police Station, Cuttack, dated 4/5/2025, which also shows that the mother of the petitioner has died. The written instruction is taken on record, considering the submission made by the Land Council for the respective party. Averments taken in the interim application, written instruction received by the Land Council for the state. We are inclined to release the petitioner on interim bail. Yes.
In course of
Yes.
But another I also type
And you fix a date so that you file the surrender order.
I number 1127 for which the interim application was filed. So at the time of interim application authorized.
IN number 1127 of 2025. This is an application for interim bail not pressed. Hello? Okay.
Item 22.
Here, the instruction, criminal.
Received instruction.
Why 3 appeals?
One arising out of one PS case. Case of acquittal, I am coming against order of acquittal by the victim. This is 3 appeals because phase wise they have surrendered and they face trial, 3 trials, but 1 judgment. This is fine. In 1, 6 appeal persons, 2 and 1.
All right, Lekhan, the Learning Council for the state has produced the written instruction received from the DSP in charge, Dikhpandi Police Station, along with the letter of the Superintendent of Police Berhampur, from which it appears that the public prosecutor Ganjam Berhampur has opined that there are sufficient grounds to prefer an appeal against the acquittal judgment passed by the trial court, and the Superintendent of Police has also agreed with the opinion of the PP Berhampur, and necessary steps were to be taken to prefer an appeal against the acquittal judgment. Put up this matter in the month of July 2025.
Notice be issued
Council for the
to the
wait. You want to state files the appeal. There is no necessary.
there is some delay. That is why I am saying that.
No, there would be no delay. The July 2025, the Land Council for the state shall apprise the court about the proposal for filing the appeals against the acquittal judgment. This is taken on record. No.
If they will prefer, state will prefer, then it will be merged with that.
Yes.